State respondent, my lord.
Item number 1 is Bali. The Bali. The writ petition is allowed. The letter dated 4th February 2016 issued by respond number 2 is cancelled. The FIR being Bali PS case number 19 of 2016 dated 5th February 2016 stands quashed. The petitioner is granted liberty to make appropriate application before the learned trial court for return of the seized raw jute. Next. Similarly, item 2 is also allowed. Letter dated 4th February issued by respond number 2 is cancelled. The FIR being Belur PS case number 28 of 2016 dated 16th February 2016 is quashed. And the petition is granted liberty to make appropriate application before the learned trial court for return of the seized raw jute.
My lord, may I permit to mention, my lord, kindly stay of the operation of this order because, my lord, we preferred an appeal, my lord.
No.
15 days, my lord. Kindly, my lord, yes.
No.
Record my submission and, my lord, refuse, please.
Lordship, the appeal was disposed of lordship during the process of withdrawal lordship. One of the claimant died, Santosh Puri. Only lordship kindly expunge the name of the area of the constable of the memorandum appeal and award be modified only to that extent the award of name of Santosh Puri may be distributed among the other claimants. Only this my
The application has been served upon Mr. Singh.
yes, lordship. Mr. Singh, I have informed also Mr. Singh. Mr. Singh has no objection if lordship will modify it in such way by recording death of one of the claimant, claimant of five Santosh Puri.
Santosh Turi.
Yes, lordship.
He was claimant number?
Claimant number 5, lordship. I have also annexed the death certificate.
Santosh Turi, son.
Last night I was informed.
Who is the widow?
Lordship.
Widow? Widow is?
All right, lordship. All right. Only Santosh Puri is the son of the deceased. He was the bachelor, lordship. So no yes. So only his name must be expunged on there.
And his share will be apportioned amongst the existing claimants. Ashwin. This matter is appearing under the heading to be mentioned. To be mentioned, to be mentioned. Mr. Amit Kumar Roy. Amit Roy. Amit Ranjan, sorry. Amit Ranjan Roy, learned advocate for appellant's claimants, submits that after passing of the order, this appeal was disposed of on 10th January 2023. Mr. Amit Ranjan Roy, learned advocate for applicants, appellants, within bracket claimants, submits that after disposal of the appeal, the appellant number 5, Santosh Turi, died on 22nd June 2023. His share Died bachelor. You have stated that he died bachelor?
Lordship, I have
Yes.
stated that. Paragraph 5, last paragraph. Page 3, state that Santosh Turi was bachelor and has no heir.
Bachelor. Died bachelor. Huh? And he has no legal heirs. He seeks for modification of the order to the extent that the share of deceased appellant dash claimant number 5 be apportioned in favor of the rest of the appellants. He informs the court that he has also intimated the learned advocate for the insurance company. It is found from the death certificate annexed to the application that Santosh Turi, appellant number 5, expired on 22nd June 2023 after the disposal of the appeal on 10th January 2023. While disposing of the appeal, the amount of compensation was directed to be released in equal proportion after payment of the spousal consortium in favor of widow of the deceased, namely appellant number 1. In view of the above, the share of deceased appellant number 5 Santosh Turi be apportioned equally amongst the remaining claimants, namely claimant number 1 to 4 and 6. The order dated 10th January 2023 is modified to the aforesaid extent. The application being heading to we can 2 of 2023. So according to this is an application for modification. The name of appellant number 5 stands expunged. The order judgment dated is modified to the above extent. The other portions of the order shall remain unaltered. The application being 10 2 of 2023 stands disposed of.
2024.
Huh?
2024.
2024. 2 of 2024.
I'm obliged.
Next.
Or my lord, I am for the petitioner along with my lord on Jacob.
Application.
The case is, my lord, a lordship, earlier occasion, a lordship directed to file the substitution application. And I also filed the substitution, but in this case, my lord, my MR dealer, my lord, tagged to the respondent number 5. And respondent number 5, my lord, died. I do not know the date of the death. Thereafter, my lord, a lordship, I directed me to serve the copy. Thereafter, serve the copy, then I came to know that one private respondent 5, died. But no death has been obtained from his village, my lord, is another village.
What is his name?
Yes, my lord.
What is his name?
Or
Respondent number 5.
Nirapodo Gayan, my lord. Nirapodo Gayan, my lord. Thereafter, my lord, I filed, as for the lordship's order, my lord, I filed a substitution application. And my lord, in this case, my lord, that substitution application may be treated as added respondent, because, my lord, it is not a property by inheritance. Only his son, my lord, also, after death of my lord, respondent number 5, his son also became by dying harness category, became a MR dealer. And my ration card holders tagged with his son also after death. That's why, my lord, that name should be added. And this application.
Who is this? Subir Gayan.
Yes, my lord.
Only Subir Gayan
Only Subir Gayan may be valid party.
son has become ever dealer.
Service to the and another application for restoration and restoration, my lord, within time. 7/2/2013 dismissed, and my lord, due to illness, my lord, the latent advocate could not appear.
Okay.
And on 3/3/2023,
Yes.
Registration is concerned, my lord, I have not objection.
objection.
So Subir Gayan has been granted the license after the demise of
Father, his father.
his father.
These instructions, lord, I have got no instructions regarding the given license or not.
Do you have the copy?
You
my
must
lord,
have a copy of the license.
I am not. No, এমআর ডিলার চলছে চালাচ্ছে দ্যাটস এবং আমার এমআর ডিলারটা রেশন কার্ড হোল্ডার ওর এখানে ট্যাগ হয়েছে দ্যাটস আ মেবি অ্যাডেড
Can 2 of 2023. This is an application for substitution. What is this?
সার্ভিস
Affidavit of service
Affidavit of
filed on
service.
behalf of the petitioner is taken on record. It's an application for substitution. Mr. So-and-so, learned advocate for the petitioner, submits that the application be treated as an application for addition of party, since after demise of respondent number 5, Govind, what is this? Respondent number 5,
নিরাপদ গায়ে
Nirapodo Gayan, the MR dealership has been license for MR dealership has been issued in favor of his son,
Subir
Subir Gayan,
So for his averment.
who is the necessary party in the present writ petition.
ঠিক আছে
Mr. Amritalal Chatterjee, learned advocate for the state respondent, gives the matter to the discretion of the court. Para. It has been categorically stated in paragraph number 10 of the application that after the death of respondent number 5, Nirapodo Gayan, his son, namely Subir Gayan, has been issued the MR dealership license at Dulduli, and the petitioner's ration card holders / beneficiaries has been presently tagged with the MR dealership of said Subir Kumar Gayan. Stop. Thus, he is a necessary party and should be impleaded. Accordingly, the name of Subir Gayan be impleaded in the array of respondents in place of deceased respondent Nirapodo Gayan. The application being Can 2 of 2022-24 stands disposed of. And
another
liberty is
application
granted to the
restoration
learned advocate for the petitioner to make necessary correction in the
and the cost item
cause title of the writ petition. Learned advocate for the petitioner is directed to serve amended copy of the writ petition upon the respondent. Added respondent number 5, Subir Gayan. Huh? কোনটা? হ্যাঁ, একদম টপে না, এখানে ঠিক জায়গায় আছে। Through registered speed post with acknowledgement due and file affidavit of service on the returnable date. The application being Can 2 of 2024 stands disposed of.
And another application for
Jan 1
restoration.
of 2023, this is an application for the restoration of the writ petition. By order dated 17th February 2023, the writ petition was dismissed for
27/2/23.
default. 17th February 2023.
And it was filed within time on 3rd
Mr.
March.
So-and-so learned advocate for the applicant submits that the learned advocate for the petitioner
Was illness.
due to illness could not attend the court when the matter was taken up, and
Yep.
the petition was dismissed for default. There is no laches or negligence on the part of the petition. He seeks for restoration of the writ petition by recalling order dated 17th February 2023. Mr. Amritulal Chatterjee, learned advocate for the state respondents, leaves the matter to the discretion of the court. Restoration application within time. ওনার সাবমিশনে পিটিশনের কবে ফাইল করেছে? হ্যাঁ, ঠিকই আছে।
3rd March.
It is contained in the application that due to illness, the learned advocate could not appear on the date the matter was taken up, which has resulted in dismissal of the writ petition. The cause should be sufficient to recall order dated 17th February 2023. Accordingly, the order dated 17th February 2023 stands recalled. The writ petition along with connected applications is restored to its original file and number. Can 1 of 2023 stands disposed of. WPA, what is the stage you will file your report?
That's why I'll come with the report, Mother.
Mr. Amritulal Chatterjee, learned advocate for state respondent, seeks to file a report in the form of affidavit. Let such report in the form of affidavit be filed by the state respondents within a period of 2 weeks after reopening. 2 weeks after reopening. Exception thereto, if any, be filed within a week thereof, let the matter appear 3 weeks after 3 weeks. No? Appear after 3 weeks after the ensuing summer vacation.
Grateful, man.
আর আছে অ্যাপ্লিকেশন
My lord, in respect to item number 5, applicable after vacation, my lord, service cannot be effected.
learned advocate for the petitioner seeks accommodation since service upon the respondent has not been affected.
What so?
On view of such submission, let the matter has not been affected as yet. Let the matter appear 2 weeks after the ensuing summer vacation. So,
Grateful, your lordship. নাম তো হ্যাঁ অ্যাডভোকেট হবে
Six matter down for the petitioner led by Mr. Prasenjit Mukherjee. But in this matter, earlier
File a
dated, your lordship has directed to file a report to the respondent authority.
what is the case?
My lord, petitioner executed a partnership deed with her grandson, and he had applied for changing the nature and character.
They wanted to make it a proprietorship form, your lordship.
No, from proprietorship to partnership.
Partnership
Yes.
from
The grandson is
that
to be
application has been
No,
rejected.
that application has been
Yes.
rejected. Where is the order?
Order of rejection.
My lord, 48 page.
What is it?
Oh. He is not a family member, the grandson. Grandson is not a family member.
No, according to my instructions, your lordship, it says that he does not, is not a family. According to the definition, which is prescribed in the act, I will just read it out to your lordship. Family member, members means spouse or son, including son legally adopted before death or incapacitation, or son's spouse, son or daughter of predeceased son, brother or sister of a bachelor spinster, daughter, including daughter legally adopted before death or incapacitation, divorced daughter and widowed daughter, who is wholly dependent on the dealer or distributor at the time of death or incapacitation.
Then cross spouse, parents, son, daughter. You are not falling within the family members.
My lord, let them file a report. My lord, Mr. Proseedings Mukherjee will argue in this matter.
Produce the last amendment.
Yes.
Mr. Benso, learned advocate for the affidavit service. On behalf of the petition is taken on record. Mr. So-and-so, learned advocate for the petitioner submits that the license, APS, this is APS license.
Yes, yes.
The APS license is
20.
that the petitioner, APS again, that the petitioner is a fair price shop dealer at village Gangnapur, Nodia. When did you file the application?
When?
On 7th June 2023, the petitioner entered into a partnership with Tovik Saha, her grandson. And accordingly, and thereafter, the petitioner submitted an application under Form C3 for issuance of license, for change of license from proprietorship to partnership. However, such prayer of the petitioner for conversion was turned down by the impugned letter, turned down by district controller. Is what number?
The DDP
Yes.
and S. What is it?
No. District controller, food and
Yes.
supplies, Nodia, was
This
turned
will be lordship, respondent number 4.
four.
Four.
Was turned down by respond number 4. District controller, food and supplies, Nodia, dates later dated 29 September 2023. Being agreed by such action of the state respondents, the petitioner has preferred the present rate petition. Ms. Sohal Sinha, learned advocate for the state respondents, seeks to file a report in the form of affidavit. Let such report in the form of affidavit be. Are there any private respondents? No.
No, my lord.
We'll file it 2 weeks after ensuing summer vacation. 1 week equivalent, filing exception if any, after 3 weeks.
Great question. Great footage.
বিয়ে হয়েছে Grateful.
On item 7, I am appearing on behalf of the petitioner, writ petitioner, my lord. This matter, my lord, relating to, my lord, petrol pump dealership, my lord. In pursuance of, my lord, advertisement in Ahmedabad Patrika on 18 July, my lord, I participate and I was currently turn, my lord, page 33.
Okay.
In response of this advertisement, my lord, and the brochure is also annexed with my writ petition, which is start from page number 34, my lord. Being a sole applicant, my lord, I got this, my lord. Kindly turn, my lord, page number 146. Result of, got it, my lord? Result of draw of lots. Name of location on RHS and on NH 34, such and such. I just skip. The fourth line, we are pleased to inform you that draw of lots for selection of retail outlet dealer for the above location is not required to be held as you are the loan applicant. So I was the loan applicant. Oblique loan remaining eligible applicant. So I was, they declared me as an eligible candidate. Eligible applicant in the location under group 1. Therefore, you have been declared as provisionally selected. So I was selected. Very next page, my lord, kindly turn page number 147. And date is very important. The date of this communication is 5th December 2023. So I got this allotment letter on 5th December 2023. Very next letter is that, my lord, 9th May 2024, page number 147. The respondent number 3, my lord, the Indian Oil Corporation, my lord, they made this email communication to me. The subject matter of this communication is that application for award of RO dealership on such and such while going from the Dhubulia to Policy, such and such, I just keep it. Dear madam, please refer to your application received by us as application form number such and such. Please also refer to our letter dated 20 October 2023 and wherein you are advised to submit certain document. However, para 3, very important. However, it is observed that land documents submitted by you are not valid for considering the offered land under group 1 for reason as detailed below. The bold point, the offered land in the application by way of lease deed is not in the possession. The word possession is very important. From where they get it, I will refer the brochure as well as my lease deed and the settled principle of law. Is not in the possession of the applicant as on the date of application. I ask this question. Anywhere it is mentioned the word possession, I will refer the brochure, my lord. Very important word. They use the word possession. In view of the above, we regret to inform you that your candidature has been found ineligible. However, your candidature may get considered for selection along with group 3 applicant as per the guidelines. So I was a group 1 applicant. I have a registered lease deed, my lord. Kindly turn, my lord, the lease deed, which is annexed with my application, my lord.
27 September 2020.
Page number 123. The lease deed executed on 27th September 2023. Got it, my lord? Which is very important date. So my lease deed executed on 27 2023. By considering this lease deed, my lord, they select me on 5th December 2023, which is annexed with my writ petition page number 146, and 9th May 2024, that is page number 147. When the lease deed is executed, on that day they says land is not in your possession. What says in their brochure, my lord? Kindly take their brochure, which is start from page number 34. Page number 34. I just refer the relevant portion of the brochure, my lord. The land, the provision of land, how I become the eligible candidate, which is start from page number 38, land, under clause 4, subclause 6, group 1. What are the conditions laid down here? Group 1. Applicants having suitable piece of land in the advertised location oblique area, either by way of ownership, stroke, long-term lease for period of minimum 19 years, 11 months, or as advertised by the OMC. Mine lease this tenure is 29 years, 6 months, more than this. Now kindly come, I believe they will refer it, and they misinterpret this provision, this part of this brochure, my lord. The last paragraph of this page, my lord, the above condition with respect to offering of land are as under. A. Well, got it, my lord?
Yes.
A. The land should be available. There is no such word of possession. There is difference between availability and possession. Here, my lord, word used, my lord, kindly see. The land should be available. I give emphasis on the word available. With the applicant as on date of application and should have minimum lease of 19 years and 11 months as advertised by the respective oil company from date or after the date of advertisement, but not later than the date of application. So land ought to be available to me on the date of application. The last date of application, they referred that last date of application. What was the last date of application? According to them, the last date of application was 17th October 2023. My execution on 27th September, prior 10-20 days, my lord.
Okay.
So on that day, land was available to me, lease deed was executed, but why they made this communication? Kindly tell the terms. And why I made these terms, my lord, I will explain in my representation. The terms mentioned in my lease deed, page number 126.
Not later than the date of
I don't know, my lord, it is in Bengal, vernacular language, pardon me, my lord, but I will, my lord, explain in English, my lord. লিজকৃত সম্পত্তি শর্তাবলী, the terms. A. অত্র লিজকৃত সম্পত্তির মেয়াদ 29 বছর 6 মাস, অর্থাৎ ইংরেজি 1/1/2024 তারিখ হইতে আগামী 30/6/2054 তারিখ পর্যন্ত বলবৎ ও ফলবৎ রইবে। ইংরেজি 1/1/2000 তারিখ হইতে লিজ প্রদত্ত জমির ভাড়া শুরু হইবে। This provision only for the starting of the rent. From when the lease deed is executed, the effect of lease start from that day. That is means 27th October 2023, the effect of lease was there. And this provision only for the rent will start from that day. 1st January 2024, rent will start. Because of that, my lord, in lease deed, my lord, it's a well settled. I will refer a judgment, my lord. And one of, in our court, one of the senior most, my lord, advocate, my lord, senior counsel, Mr. Shoktinath Mukherjee argued in this matter, my lord. A lease deed execution of the lease deed is paramount consideration. When a lease deed is executed, it might be, it affects from any anterior date or any posterior date. But lease will be effect from the execution. What they says in their brochure, they says land will be available with you. Land is available with me, but
Ah.
rent will start from 1st January 2024. Because of that, but I am a
Yes, yes.
I am a
After you
pledged
complete
woman.
1 month, you start paying the rent.
Yes. So, my lord, land was available on that day. They misinterpret and misquote this provision, this terms, my lord. They misquote it. So, land was available on that day. I start giving rent from 1st January 2024. My lord, kindly set aside this communication, and it is well settled. I just want to refer, my lord. I know my lord is well aware of the fact, my lord. I just want to refer this judgment, my lord, para 7. আমি সাইটেশনটা বলে দিচ্ছি।
You have prayed for
Nine.
consideration of your representation.
Yes,
Consideration.
I made yes, my lord. Sorry, my lord. Pardon me. Yes, my lord. The representation is annexed my page number 148, my lord. I read this representation, and thereafter they consider the representation, and they made a email communication that is also annexed with my representation, page number 152. I just read my lord representation. Kindly read the representation, my lord. It give a clear picture.
Date, but not later than date of application.
May I read, my lord? Yes, my lord. I have got your email on 9th May 2024, page number 148, my lord. After going through your apostate mail, I would like to draw your kind attention in the following matters.
Date of application.
In pursuance of my application bearing number such and such for getting RO dealership on such and such, while going from Dubulia to policy such and such, I just skip it. Be it mentioned that as per eligible criteria for individual applicant required under clause 4, subclause 6 of group 1 category in individual, applicant having suitable piece of land in the advertised location either by way of ownership, stroke long-term lease for a period of minimum 19 years, 11 months. I have complied the criteria in all respects. And ultimately, I am able to get suitable plot covering all criteria on group 1 candidate. The copy of lease deed is annexed herewith for your perusal. The closing date, the very next page, page number 149. The closing date of submission of application was on 17th October 2023. And within that period, I had a registered lease deed of required land. The land schedule of lease deed registered on 27th September 2023, and the lease deed under the provision of section 105 of TP Act, the applicant acquired to enjoy the leasehold land to have effect from 1st January 2024. Therefore, the applicant had the lease before the closing date, but the enjoyment deferred till 1st January 2024. This was done to avoid the payment of rent amounting of rupees 55,833 per month. There was no clause in the advertisement that the applicant was required to have actual physical possession before the closing date. That on the date of application, registered deed of lease for 29 years, 6 months in respect of the above land was in my name, and the same was
Yes, yes.
available.
Yes.
It was sufficient. So, my lord, that is well settled. And my lord passed a judgment in this regard, and I go through that judgment, and it is in my favor. In Malat Nibir Sarkar versus Indian Oil Corporation Limited, although Malat reputation dismissed, but Malat stand is that if I got it properly, the tenant of this judgment is that Malat, the lease deed ought to be executed before closing date. My lease deed was executed. So Malat, that's why respectful submission, and kindly take Malat the judgment which I referred Malat. I want to refer Malat. That is Sri Baneshwar Pal versus Srimati Nirmala Jyoti, that is citation 1979 2 CHN 214.
Please,
Para 7 মারাট আমি একটা কপি তোমাদের দিয়ে দিচ্ছি না para 7 মারাট because commentary is there malat to well settled law books in this regard malat. The middle portion of this paragraph malat, this is 1 2 3 4 5 6 7 8 9 10 11 22nd line onwards malat. This is so according to the comment appearing, Mulla is quoted and Hill and Redmans is quoted. Specifically Hill and Redman is very
yes, yes.
important.
It starts from the registered lease, I suppose.
Malat Mulla and Hill Hill and Redman is quoted, my lord.
Paragraph
Paragraph 7, the last, the quotation is very important, within quote, my lord. The very
No,
next page, my lord.
Perhaps you are referring to
Para
when sentence
7.
starts with the said registered deed lease was executed on.
Yes.
I suppose this. It says that the execution or date is to for computation of the
My lord, kindly turn, my lord, the very next page, my lord, within quote it is mentioned. Because it is mentioned.
term commence.
May I read, my lord?
Yes, yes.
This is so according to comment appearing in Mulla on Transfer of Property Act 1882 on 6th edition, page number such and such. In the present case, as already stated, the deed of lease was executed on February 21, 1956, but according to the term contained in the deed of lease, the lease was to commence from November 1953. That is from a date of anterior to the date of execution. Here, therefore, for the purpose of computation of the period of 14 years, which was the term for which the lease was created, one has to start from November 1953, and that being so, the lease was to terminate on the expiry of the month of October 1967. But the duration for which the lease will be effective will be the period from February 21, 1956 to the end of October 1967. This view finds support from the observation made at page 54 of Hill and Redman's law on landlord and tenant. There at page 54, the following comments appear within quote, very important. The term may commence either immediately or from a past or future date. In my case, future date. And although it is expressed to commence from a past date, yet the actual interest of the leasee commences only on the execution of the lease. Very important. So execution of the lease is important, and his liability is limited accordingly. Thus, he is not liable for matters arising before the date of execution under the covenant repair such and such. And I also want to, my lord, read the section 105 of TP Act, the definition of lease. That is for the
once again refer to the lease deed where the period has been mentioned that it will commence. You have just read.
Yes, my lord. I read it again, my lord, within the quote. The term may commence either immediately, that means from the date of.
That I have seen. In the lease deed executed between the parties, you have just read the date from which it will
Yes, my
commence.
lord. I just read it again, my lord, for my. The term may commence either immediately or from a past or future date. And although it is expressed to commence from a past date, yet the actual interest of the leasing commences only on the execution of the lease. So, my lord, execution of the lease is the paramount consideration. That's my keyword. So, execution of lease is 27th September 2023 in my case. So, from that day, lease is executed. So, effect of the lease start from that day. Land might be rent might be given on deferred date, any date, but lease deed executed on 27th September 2023, and the paramount consideration for a lease deed is that execution. And a lease deed already executed, and in that brochure they not says about possession, this says about availability. So my land is available from 27th September in my case to 2023, my lord. And the definition of lease is very much clear, my lord. So that is says about the tenure, how it might be 20 years, 30 years for giving the rent. But lease is the paramount consideration. What the instrumentality of lease? May I read the definition? I know it is not required, although I know I have faith of the court. Okay. So, my lease, my lease was. May I read? May I hand it over? I have one copy. Pardon me, my lord.
105.
105, man. Bueno. Definition 105.
Yes.
A lease of immovable property is a transfer of right. So it's a transfer of right to enjoy such property made for a certain time. So the enjoyability of this property starts from 27th September 2023 in my case. Expressed or implied or in perpetuity in consideration of price paid or promised or a share of stock, service or any other thing of value to be rendered periodically or on specified occasion to the transferor by the transferee who accept the transfer on such terms. So enjoyment is very important. So I enjoyed that lease from the 27th September 2023. The rental payment is deferred. That is deferred payment. That is in between us, my lord. But land available with me, lease deed was executed prior closing date. So my case is a well settled in terms of brochure. I'm eligible candidate. So my lord, by
Yes,
satisfy all the email, my lord,
Yes.
kindly give.
Yes, Mr. Nag.
May I place the certain important points? The last day of submission of application was 17th of October 2023, and that is an admitted position. Kindly see page 3, para 3 of the writ petition.
17th October 2023 is the closing date.
Closing date. Now, kindly see the eligibility criteria. Page 37 first, my lord.
Yes.
'37 is the eligibility criteria, and the next page 38. Roman 4. Land applicable to all categories. Page 38, Roman 4.
6.
Roman 6, sorry. Roman 6. Now there are 3 groups under which application can be made. Group 1, Group 2, and Group 3. Group 1 is the persons who will possess a land at the date of application. Now the possession of land can be either by way of title or by way of a registered lease deed for a period more than 19 years, 11 months. Now kindly see the clause 6. The applicants would be classified into 3 groups as mentioned below based on the land offer or land not offered by them in the application form. Group 1. Applicants having suitable piece of land in the award have kindly emphasize on this point. Applicants having, then that means the applicant should having suitable piece of land in the advertised location area, either by way of ownership or long-term lease for a period of 19 years, 11 months, or as advertised by the OMC. Now the criteria is, if you are applying for group 1, then you need to have a land as on the date of your application, either by way of ownership like title, that can be through your family units also, or by under a registered lease for a period more than 19 years, 11 months. This is the criteria. Now kindly see the clause under the same clause A at the bottom. The land should be available. That means when the land should be available with the applicant as on the date of application, and should have minimum lease of 19 years and 11 months as advertised by respective oil company from the date or after the date of advertisement, but not later than the date of application. So as on the date of application, a land should be with you. Availability, the land should be available means you should possess. You should have the land with you. Even the group 1 definition says so. Applicants having suitable piece of land as well as A. So you need to have the land.
Yes.
Either by of title or by of registered lease. Now kindly sees the but if you are holding the land, possess the land, holding the land under a lease, then it is an admitted position. You need to have a registered lease deed. Now kindly sees the also the definition of ownership, page 42. Note 1, page 42, note 1. Note 1A. Own means having ownership by way of registered lease sale deed, registered gift deed, etc., or title of the property, or registered long lease in the applicant name, family members as defined in clause 4(6) and clause 4(6)H. So clause 4(6) I have referred. If you are applying as with a leasehold right on the offered land, you need to have the land on the date of application. That land should be with you. Now kindly see. My learned friend is saying that he is going on the term used in the cancellation. Is going on the term used in the cancellation. My lord, your losses knows the term can be interpreted in many ways. The actual meaning should be construed as per the eligibility criteria. I may have used the term possession without like using the term available. What I have said, my learned friend has not shown the letter which was issued subsequently after he filed the representation. Kindly come to page. Page number 152.
Yes.
I have specifically cited the exact eligibility criteria which the writ petitioner could not fulfill. This is
Yes.
the below matter was deliberated one against and in the reply given below with reference to submitted lease and clause 6D, 4(6)D. Now kindly sees, my lord, his application. Page 120.
Yes.
Now page 120, clause number 9, to show under which group the writ petitioner applied. Point number 9, column 9. Group 1. Now date of application is 27 September 2023. Now the next page, page 121.
Yes.
Now the land offer is under lease. This chart given. Date of registration is 27 September. Nupur Haldar is the leasehold, the lessee. So under lease holding, she has given this. Now kindly see the just below the chart, the declaration. Just below the chart, the fourth line from below the chart. That as per the documents available with me, as my or our offer qualifies for being considered under group 1 as defined in clause 4(6) of the brochure. So this is the declaration given by the applicant saying that she is eligible under clause 4(6). She meets the criteria under 4(6) of the brochure.
Yes.
Now kindly sees the undertaking. Column 15, undertaking by the applicant. Then A, on that page itself, 15A, column 15, just below column 15A. I am aware that eligibility of retail outlet dealership will be decided based on the information given in the application form. Because your losses knows that I have this, the procedure is, while applying, no documents is required to be submitted. It's an online application form only required to be filled up, and thereafter, subsequent to a draw of lots, whoever is selected, he or she will be called for furnishing documents. So at the time of application, only this information is given on the online application. No supporting documents are submitted. So there is no scope, as my learned friend said, that they have already scrutinized my documents and thereafter provisionally selected. That is not correct. Because no documents were considered, because there were no documents at all. Because along with the application, there is no provision for submission of any supporting documents. Only you have to give the particulars, fill up the application form, and whenever you are selected through a draw of lots, you will be called on for submission of documents. Now this undertaking further says, on verification by the Oil Company, Indian Oil Corporation, if it is found that the information given by me is incorrect, false, represented, then my candidature will stand cancelled and I will be declared ineligible for the retail outlet dealership. Now the very next page, 122, there is a declaration to that effect also, another declaration at page 122. I, Nupur Haldar Mistry, wife of such and such, hereby confirm that the information given above is true and correct. Any wrong information, misrepresentation, suppression of facts will make me ineligible for this RO dealership. That if any information declaration given by me in my application or in any document submitted by me in support of my application for the award of dealership shall be found to be untrue or incorrect or false, the Indian Oil Corporation would be within its right to withdraw the letter of intent, terminate the dealership, and that would be no claim whatsoever. Now kindly see the after this what had happened. There was a draw of lots after submission of this application. There was a draw of lots. In the draw of lots, the writ petitioner was selected. Now after the writ petitioner got selected, an intimation was sent to her, which my learned friend has also placed at page 146.
Yes.
In this case, since she was the loan applicant, so no draw of lots as per the procedure, no draw of lots conducted, and she got selected. Kindly see page 146. We are pleased to inform you that the draw of lots for selection of retail outlet dealer of the above location is not required to be held, as you are the loan applicant, remaining eligible applicant in the location under group 1. So under group 1, only one candidate applied, and which is the writ petitioner. So there was no draw of lots, because after exhausting group 1 candidates, then only the other candidates who have applied under other groups like group 3 and group 2 and 3, they will be in the queue for selection. So since she was the lone candidate under group 1, with no draw of lots conducted, and she got provisionally selected. Now kindly see, but that is provisional selection and subject to compliance of the terms and conditions of the selection. Therefore, you have been declared as provisionally selected. This is only a preliminary intimation towards your provisional selection for the retail outlet dealership. However, the award of the dealership is subject to compliance of the terms and conditions of the corporation in this regard. So this is only a provisional selection. All the after considering all the documents, credentials and documents, the candidate needs to satisfy all the terms and conditions. Otherwise, this selection is liable to be cancelled. Now, the next page 147. Petition on the very same date, petitioner was again. No, not this one, my lord. This is the cancellation. Now, thereafter, the petitioner has not annexed that document. Petitioner was called for submission of required documents. Now, kindly see the brochure. What are the required documents to be submitted?
Yes.
Page 39 of the repetition.
39.
Page 39, clause F. This I am placing because the requirement is if it is a leasehold property, then registered lease deed. Only to show that. Now, what are the other documents which are required to be submitted?
Scott, yes, complied. There is no dispute that it was prior to the last date of application.
Which one? ma'am?
Execution and registration of the lease deed is within the period.
Yes.
This is not disputed.
No.
The only dispute is that his period starts from 1st January 2024, whereas the lease has been executed on 27 September 2023, whether the land was available with him or not.
Right.
That is the only situation.
Because what I am saying that as per that clause A, two things are required to be satisfied. One is availability of the land with the applicant as on the date of application, and second is a registered lease deed. So these are the two criteria. Now, my lord, kindly come to pay the lease deed now. The clause which my learned friend has shown at page 126, অত্র লিজকৃত সম্পত্তির মেয়াদ 29 বছর 6 মাস অর্থাৎ ইংরেজি 1/1/2024 তারিখ হইতে আগামী 30/6/2054 তারিখ পর্যন্ত বলবৎ অন ফলবৎ রহিবে। That means what? This lease is effective. The date of commencement of the lease is from 1st January. On the date of application, there was no lease in respect of this property at all. Commencement commencement, as it says, ফলবৎ ও বলবৎ রইবে. So commence, it is not only when the as my learned friend tried to portray it, that this date is given only to indicate from which date the rent has to be deposited. That is not the case. It says it will be বলবৎ and it will be effective, it will commence an effect. It will come into effect and it will commence. The lease will commence and come into effect only from 1st of January 2024. It is not only for the purpose of payment of rents. ফলবৎ রইবে ইংরেজি এত তারিখ হইতে
No,
কমা ইংরেজি কমা আফটার রইবে, দেন after a comma ইংরেজি এত তারিখ 1/1/2024 তারিখ হইতে লিস্ট, because it is very natural. If the lease is commencing from a future date, no rent can be payable before that.
1979 is the answer.
Yes.
1979 is the answer.
No, yes, it was not only 17, it has the answer, but it was not, the actual meaning was not placed before the lordship. I have other judgments to show, but even from 79 also, it will support my case, not his case. 79 says the date of a lease. In all the lease, a date of commencement of lease is not always specifically mentioned. Date of commencement of lease in every instrument of lease is not always categorically mentioned. Number one. Second, sometimes it gives an effect from an anterior date. Commencement is from an anterior date, and sometimes commencement from a posterior date. These three situations always happen. Now, 1979 says when if the commencement is from an anterior date, then the date of execution will be considered. Yes, kindly see. Yes.
You come to paragraph 7, he has referred.
Yes,
in the
kindly see.
judgment.
Kindly see. May I place the from page paragraph 7 from page
7
number
is the relevant paragraph.
7 is relevant paragraph.
In that case, in the case referred, this
May I place from after the word October 1967?
yes.
Ordinarily, a lease may commence either from the date of its execution or a date later than the date of execution.
Yes.
Right? This is in ordinary case. In other words, a lease may commence either simultaneously with the execution of the lease deed or at a future date.
Which is the case in the present.
Yes, but what was the case there? But in cases where a lease is expressed to commence from a date anterior to the date of execution of the lease, such anterior date would be material only for the purpose of computation of the period of the lease when it is one from a term of years, but the interest of the lessee under the deed cannot be said to begin from the date anterior date. See, so only it's from an anterior date, not it is not applicable for the
That is-
posterior date.
That is what he is submitting.
No,
And the interest of the lessee will commence from date of execution and not from the anterior or posterior date.
no, it doesn't say or posterior. It
Come-
doesn't.
You come to
Man,
last
kindly
section
see.
of
Yes, yes, I am coming. It will commence from the date of execution of the lease deed and not from the anterior date. It doesn't say anterior or posterior. Anterior date from which the lease is expected to commence.
Huh.
Now kindly see the next one. Let us read the other parts also. This is so according to the comments appearing in Mulla on the Transfer of Property Act 1882, 6th edition, pages 645, 646. In the present case, as already stated, the date of lease was executed on February 21, 1956. But according to the terms contained in the deed of lease, the lease was to commence from 1953. That is from a date anterior to the date of execution. So there the case was anterior. Here, therefore, for the purpose of computation of the period of 14 years, which was the term for which the lease was created, one has to start from November 1953 and That being so, the lease was to terminate on the expiry of the month of October 1967. But the duration for
No, no.
which the lease will be effective
Read this
will
line
be,
again. Read this line, but
yes,
the date of, in that case, the date of execution was 21st February 1956.
anterior date.
After explaining all, the court says that, but the duration of the lease will be effective from the period February 21, 1956.
Because
that is the date
because
of
of the because execute when it is having a commencement date of anterior date, then execution has to be considered. Then execution has to be considered. But the duration for which the lease was effective will be period from February 21, 1956 to the end October 1967. This view finds support from the observation made at page 54 of Hill and Redmond's Law on Landlord and Tenant, 15th edition. There at page 54, the following comments appear. Now kindly see what was the comments. The term may commence either immediately or from a past or future date. These are the three scenarios. Now,
Mr. Nath, I just give you an example. Suppose lease is not like rent. Suppose there is a lease deed where the execution is made on such and such date. The lease deed says that the lessee will deposit the lease rent on December of that month, but that year. So you say that from December he will be in possession.
no. I'm saying commencement. I'm not saying
So
start.
that makes the come to the other portion, the last portion, which
Yes.
makes it very clear that you are with whether any interest is created or not. Right?
Right.
Upon execution, it says that the interest is created.
No, it doesn't say so. When the commencement is of an anterior date, only in that case, kindly see, my lord, the
No.
term may commence either immediately or from a past or future date. And although it is expressed to commence from a past date, yet the actual interest of the lessee commences only on the execution of the lease. This is the reason, because if you are mentioning a date anterior to the date of execution, you can't say that you have the interest prior to the date when you are signing the document. Only in that situation, my lord, the actual interest of the lessee commences only on execution of the lease, and its liability is limited accordingly. Thus, he is not liable for matters arising before the date of execution under the covenant. So the entire situation was the issue was whether when the date of commencement is having a retrospective date.
What is the clause that there should be availability?
Right.
Correct.
In none of the
If a lease deed commences on execution of a particular date, interest. What is the interest of a lessee in the land? He is a lessor.
Right.
His interest is created on the commencement of the lease deed.
Right, commencement. Now that is
Commencing.
clause 20 that the lease that I have shown page 126 when it's commenced.
Page? No, again you are arguing on dates.
No. Date of commencement, kindly sees it says.
No, it has been clarified in 1979. He is granted liberty. No, I'm giving him liberty to file a fresh representation.
My lord, kindly convert. No, there, my lord, kindly place. Let me place other cases also, my lord, on exactly on the
This is
similar.
too much technicality.
No, this is not too much technicality, my lord. On the similar situation, this honorable court as well as the honorable Supreme Court has held. What should be the scenario? What should be the consideration?
Okay. Then I admit his motion. You file your opposition to that. In the meantime, you don't.
On the grant of, kindly consider these judgments. What I am relying, my lord. The honorable Supreme Court says in similar situation, this similar situation case was considered. Well, kindly says this judgment now.
Copy the citation.
This is about into 2021 SSC Online Supreme Court 852. Now kindly see what was the fact, my lord. 11. Kindly see 11. However, this is not clear to be. It is this not there to the end of the inquiry. The requirement under the clause is that this number of points marks to the applicant must have an inter-year long-term lease registered from a minimum of 19 years 11 months as on the date of application. Now kindly consider, in same case also the date of commencement was of a future date. Now kindly see page para 15.
130
Para 15.
as on date of application. Page
मतलब para 15, paragraph 15. A lease of immovable property is a transfer of immovable property. The transfer consists of the transfer of a right to enjoy immovable property. It creates an interest in the property. One of the essential elements of the lease is the period of time for which the demise holds good. A lease may be for a certain time which may be expressed or implied. It may be so it may be in perpetuity. Therefore, when one thinks a lease of an immovable property, one of the essential terms would be the period for which the lease operates. In this case, the lease or the period of lease is 30 years. The question would immediately arise as to when the lease bears life. The expression certain term is premised on there being a beginning in point of time and the end again with a reference to time. Certain time would be, in other words, be the period of time. The answer is given by lessee itself, by the lease itself, namely that the period begins with effect from the date of approval of the petrol pump. In other words, here is a lease deed which contemplated the period of the lease commencing at a point of time in future, which is exactly in our case, a point of time in future. What is more, would commence only from the date of the effect of the approval of the petrol pump. The parties in contemplated in clause 7 that the case of the petrol pump was not approved, then the appellant will hand over. Now kindly see para 17. The fourth line from top. Therefore, it is clear that the lease which the appellant laid store by contemplated the period of the lease commencing not on the date of the lease, but at a point of time in future. In fact, the point of the point of time or the event upon which the period of lease was to begin with itself uncertain. Maybe it is true that it could come effect in the future events taking shape on the principle that is equity on future event happening relating to the subject matter of the lease would affect the property in the future. But we need to explore the matter on those lines any further, as it is clear that the lease did not take effect on the date of the lease, namely 8/11/2011. If that be so, then there was no lease in place as on the date of application, namely 11 November. Here also in the lease deed specifically says that the lease will commence from 1st of January 2024. Lease will operate from 1st of January 2024. It says it will commence from 1st of January 2024. Now, not only that, the other clause which from clause 16 at page 130 of the lease, kindly see, may I place that also? Page 130 of the writ petition, the other clause number 16. It says the period of lease, which is the period of lease, specifically says so. Clause 16. 1/1/2024 হইতে 30/6/2024 পর্যন্ত নির্ধারিত এত মাস মেয়াদ অতিক্রম কইলে, so what is the মেয়াদ অতিক্রম? Then period, মেয়াদ is mentioned here, the period is mentioned here. When this is the commencement of the lease, 1st January 2024 is the commencement of the lease. Now, my colleagues say what our division bench on this similar facts and situation, even if that was on a worse scenario also. My colleagues is what our division bench in one of the matter on similar facts has said. My lord, may I place this judgment? Even in that case, even in this case, there was a subsequent document by way of a declaration. The commencement was rectified. In our case, even that is also not the case. There is no rectification in future. In future also. My lord is saying, my lord, the our division bench judgment, my lord, 2020.
No, this is the Supreme Court
Sir, that is one. The next one which I want to rely on. This is the judgment of Nibir Sarkar, your lordship, has also relied upon this judgment on a different aspect, the compliance of the terms in its true meaning. That is a requirement that has to be complied with. But what was the case exactly? The case was similar to this. My lord, may I first place para 8? What was the case here? Para 8. Honorable single judge, relying on an earlier decision of this court rendered by coordinate bench in the case of Polasray versus Union of India, held that so far as the land offered for godown is concerned, the petitioner case is covered for the decision rendered by this case in the case of Polasray Supra. So far as the commencement of lease is concerned, Honorable single bench, relying on section 105 of the Transfer of Property Act 1982, held that though the date of commencement of the lease was later to the date of execution of the lease deed, that is 16th October 2017, and the mistake in the date of commencement of the lease deed was later rectified and date of commencement of the lease deed was corrected to 16th October 2017, it cannot be held that possession was not handed over to the lessee, that is the present respondent number 1 by the lessor on the date of execution of the lease deed, in as much as there is no mention in the lease deed regarding possession to be given on a future date of commencement of the lease. It is further held that both the lease deed and the declaration of the rectification having been duly registered and the mistake having been corrected, and especially in view of section 105 of the Transfer of Property Act 1882, court is not convinced that for the interregnum period, that is from the date of registration of the lease deed till the date of commencement of the lease deed, as mistakenly mentioned, no consideration was paid, and therefore it was to be held that the lease so rectified is to commence with effect from October 16, 2017 and continue to the 31st October 2033, especially when premium by way of salami was paid with execution of the lease on 16th October 2017. So this was the exactly the fact which was consideration which was duly considered by the learned single judge. Now, my lord, kindly consider the other part. Now, what was the submission? What was the criteria in that case? The eligibility criteria. If you also kindly see para 11, the clause, the requirement has been quoted here. Provided following details of the plot of land of construction LPG godown or the construction of LPG owned or registered lease deed for 15 years in the name of the applicant of the family unit commencing on the date of the advertisement up to the last date of submission of the application as specified earlier in the advertisement. So here the criteria was there should be a registered lease of 15 years having a date of commencement from the date of advertisement or at maximum the last date of submission. So that was the criteria. Now kindly consider para 27.
Yes.
Para 27 is what your lawsuits are also held in Nibir Sarkar's judgment, that it is no more race entry, that what is strict, all the terms and condition has to be strictly followed. Now kindly consider the issue. What is the decision of the honorable division bench on the hand in issue on the issue? Para 49. Para 49, my lord, kindly come. The aforesaid decision of Honorable Supreme Court in the case of Ramana Dayaram Shetty is now has attained the status of locus calcicus. Taking a cue from the aforesaid judgment, we feel it expedient to say here that any act done in contravention of the norms vitiates the action irrespective of whether it involves affection of some right or denial of some privilege. In the present case, as we have discussed supra and as found from the statement of respondent number 1 in annexation number such and such, the land for go down offered by her by the last date of application such was not in accordance with the norms specified in the advert, that is the invitation to offer any development, because in that case there was a deed by our deed of declaration, the date of commence was sought to be corrected, because date of declaration, the commencement was with the prospective date, and by our deed of declaration subsequently it was tried to be corrected. Now even in that case also the honorable court has said that not permissible. Now kindly see para 55. So far as the decision relayed by Mr. Bandopadhyay, learned senior counsel appearing on behalf of the respondent number 1 in case of Prasad Technology Park Supra is concerned, it speaks of a relation between the lessor and the lessee in the event of alteration made in the lease deed afterwards, and we do not dispute that the proposition of law that unless the essential ingredients as contained in section 105 of the Transferable Property Act are altered, it cannot be said that the parties to the contract entered into a fresh transaction. This is the relation in respect between the lessor and lessee. Now, the aforesaid decision is in any manner does not answer our question. Per contra, the decision of the Honorable Supreme Court in the case of Annapurna Jaswal, as I have, Elosis, I have relayed the first judgment that I have relayed. By Mr. Mitro, learned senior counsel appearing for the appellant, squarely applies to the facts of the present case as found from the paragraphs 14 to 20 of the said judgment. In view of our discussion, we are constrained to hold that on the date of submission of the application, that is 18th October 2017, there was no subsisting lease, because commencement is of a posterior date. There was no subsisting lease in favor of the respondent number 1, though the lease was commencing from a posterior date, and it was rectified later by action of the lessor and the lessee. Then 58, taking into consideration our discussion supra, we constrained to set aside the impugned judgment and order dated such and accordingly allowed the appeal. Cancellation was upheld. Now, my lord, kindly sees my learned friend has shown section 105. The one of the main ingredient of section 105, that what should be the valid consideration so far as a valid lease is concerned. The one of the main criteria ingredient of a valid lease of a movable property is exclusive possession, transfer of exclusive possession. The interest by which through a lease, the interest of the original owner is transferred through a lease is the exclusive possession. Exclusive possession has to be in kindly sees না না আমি তো বলবো চলতে পারে। Oh, my lord, kindly sees now kindly sees my lord, this is But this is reported in Indian Law Reporter 1939. Now kindly sees the issue, the possession. I specifically mentioned that the why this what availability means the candidate needs to possess the land as on the date of application. So exclude because why? Because exclusive possession is the main criteria of a registered deed. Now kindly sees in the register in the lease deed, there is not a single line which says that possession has been handed over along with the execution. There is not a single step covenant in the lease deed. It says commencement, so it can always be implied that whenever the lease is commenced, he will be given possession. The possession will be given to him only when the lease commences, unless it is specifically mentioned. It is not mentioned in the upon execution it was handed over. It is not his case also in any of the repetition that he possessed the lease. The land was available with him. That he possessed the land as on the date of application. Now kindly see the internal page 256 of this judgment. Quoting the section 135, the middle paragraph, quoting section 105 of the transfer of property, what the Honorable Court says. A lease is therefore the outcome of rightful separation of ownership and possession. So this is the distinction between transfer by sale and transfer by lease. The outcome of rightful separation of ownership and possession. The essential characteristics of a lease is that the subject is occupied and enjoyed, but the corpus of the subject does not disappear by the user. Before the lease, the owner had the right to enjoy possession of the lease, but by the lease he excludes himself during its currency. Kindly mark this one. During its currency from that right. So possession will always be deemed, even if it is not written. Possession will always be deemed to have been transferred during the currency of the lease.
My friends, they continue.
Make me understand what is lease and what is the period from where the commencement of lease will come. This Mr. Nag is arguing now.
And as I'm told, the next matter that will also take some time. And
Which one?
8, 9, mine is 11.
Those
are identical matters. I will take hardly 5, 6. সবাই তাই বলছে হচ্ছে না তাহলে আরো লেট ওয়েট ফর সাম টাইম তাহলে এই বলেই গিয়েছিল ভালো করে পড়তো আমার টিভিতে মুখ দেখিয়ে বলে বলেছে ভালো বলে
Yes. Yes, Mr. Nag.
So before the lease, the owner had the right to enjoy possession of the land, but by the lease he excludes himself during its currency from that right. So during its currency. So during the tenure of the lease, during the currency of the lease, possession will be transferred. There will be a deemed, even if it is not written in the lease deed, there will be a deemed transfer of possession.
That has not been stated.
Not been stated. Then when it is not stated, then currency. Tenure. The effect of lease, the lease period. Currency of the lease deed means the lease period. Admittedly, the lease period is from 1st of January 2024. That is an admitted position, even from the pleading from the writ petition as well as from the lease date itself. Now, my lord, kindly consider one judgment of the Honorable Supreme Court. There also this question cropped up. When it is given, the effect was the date of commencement was given from a future date. Then whether the execution will be considered. It says no, because you are not giving the exclusive possession. When you are saying that you will be paying rent from a particular date, that means you are saying from particular date, that means the commencement. So before commencement, you won't have an exclusive possession. So commencement is very much important. If losses are having the Bare Act of the Transfer of Property Act,
Yes.
the না না ওইখানে this reference is in the explanation, in the note, in the Bare Act itself, after in 105, section 105, the reference of this judgment is also given.
Is it,
না এটার মধ্যে আপনার ওই এটা Bare Act
what is the reference?
this is the this is 1989 one Supreme Court cases, page 19.
Yes. Paragraph.
Now para 22, then para 24, because in that case the Honorable Supreme Court was deciding the issue relating to distinction between a license and a lease. One of the main distinction is with license, in case of license, there is no transfer of exclusive possession, which is an ingredient of lease. So handover of exclusive possession is an ingredient, the main ingredient of lease. The lease deed does not, there is not a covenant, in single covenant in the lease deed which has been executed by the petitioner, that the possession was handed over immediately upon execution. Now, when it is not expressly mentioned and a date of commencement of the lease is mentioned, the period from during which the lease will operate is mentioned, the possession will always be deemed to have been given during that period.
Where is that? Where is that?
This I have shown clause number 1 and 16 in the lease deed.
That is there in the lease deed.
In
the
one,
judgment, in the judgment you have referred. In the judgment that you have referred, right?
No, the 1989 judgment I have referred with regard to the exclusive possession. It is an ingredient, is a main ingredient of a valid lease. If you are claiming your right over on a buy of a lease, you have to show that there is an handover, there's not a transfer of exclusive possession.
Okay.
Now, kindly says the representation also. Page 149, in the representation also, what he has written. Specifically referred at clear admission when it got affected. Second paragraph, the land schedule of the lease deed registered on 27 September 2023 and the lease deed under the Provision Transfer of Property Act. The applicant acquired to enjoy the leasehold right to have effect from 1st January 2024. specifically says it is giving effect from 1st of January. The date of commencement is 1st of January. And then those two clauses I have shown from the lease deed, my lord, that clause number at page 126, which my learned friend has also shown, clause 1, it says during which period it will ball both and fall both operate and will be effective, commencement and effect. The word
Yes, sir.
ball, this is one, and then the other one that I have shown, my lord, clause number 16 at page 130. It also says the tenure of the lease. Clause number 16 at page 130. During which period the lease will operate.
Page 130.
130, clause number 16.
Yes.
Mead. So this is the mead. This is see. So, my lord, as the clause, the requirement is the land should be available with you. There has to be a registered lease deed. And lease, these are the two criteria. The document does not say the lease deed relied upon. The lease, there is not a single document, there not a covenant in the lease deed that the land was handed over to him on the date of execution.
Yes.
Now, so far as registration is concerned, if in case of a registered lease, that as on, because the honorable division or division bench said that the as on the date of, since it was the date of commencement is of a future date, so there was no registered lease deed in respect of the offered land as on the date of application.
That you have shown.
Yes, the division bench, my lord, they show that Shoma.
Paragraph 55.
Yes.
Shoma Shah.
And the Honorable Supreme Court's judgment, my lord, Annapurna Jaiswal, even in that case also, the same thing was decided, and it's also related to this selection of the oil company. And the criteria also similar. This criteria was there should be a lease. The period of lease was less, but there should be a lease. The honorable, before the Honorable Supreme Court, the lease was of 19 years. So there has to be a lease. In that case also, that the effect of the lease was given on a future date. So in that case, Honorable Supreme Court said when you are giving when the lease says that it will have an effect on a future date, then on the date of application there was no lease.
Yes.
I am extremely grateful, my lord, for clarify the stand of the OMCs, because the submission is very much clear. Twofold criteria. One is that you have to be registered deed. That's I have. Second thing is that land available. My learned friend argument so many times, but it's not able to show from the brochure there is any word of possession. This says available. My learned friend referred the lease terms, para 1, my learned friend referred. My learned friend referred para 16, I believe so. Para 1 is for the which purpose? Para 1 for the purpose of starting rent. I read the whole word, my lord, and I translate it. অত্ত লিজকৃত সম্পত্তির মেয়াদ 29 বছর 6 মাস, অর্থাৎ ইংরেজি 1/1/2024 তারিখ হইতে আগামী 30/6/2054 তারিখ পর্যন্ত বলবৎ এবং ফলবৎ রহিবে। দেনে কমা, ইংরেজি 1/1/2024 তারিখ হইতে লিজ প্রদত্ত জমির ভাড়া শুরু হইবে। The purpose of this terms is that from when this rent will start. Rent will start from 1st January 2024. I read whole the terms, but I specifically give emphasis on terms 9 minor. But I want to read the whole terms. লিজকৃত সম্পত্তির মাসিক ভাড়া 34,167 টাকা মূল্য ধার্য হইল। যাহা 1 নাম্বার লিজ দাতা 12,500 টাকা, 2 নম্বর লিজ দাতা 10,800, such and such. I just keep it. লিজকৃত সম্পত্তির বর্তমানে, তো on that day হাউস শ্রেণীভুক্ত হইতেছে, so there is a mentioning the present date, there is a word বর্তমানে। লিজকৃত সম্পত্তির সাবলিজ দেওয়ার অধিকার লিজ গ্রহীতা থাকবে, so lessee and lessor, the relation is that anytime they can give sublease. That is not mentioned from that day, no, anytime. Fifth, লিজকৃত সম্পত্তির খাজনাদি রাজস্বাদি লিজ গ্রহীতার লিজের মেয়াদ থাকাকালীন নিজ খরচে বহন করিবে। 6, লিজকৃত সম্পত্তি লিজ দেওয়ার পরে, তো লিজ দেওয়ার পরে from which date they give the lease? On 27 September 2023. লিজ দাতা সম্পত্তির কোন প্রকার হস্তান্তর বিক্রয় বন্ধকাদি রাখিতে পারবেন না, so land is available with me. The term 6 is very clear. The লিজকৃত সম্পত্তি লিজ দেওয়ার পরে লিজ দাতা সম্পত্তির কোন প্রকার হস্তান্তর বিক্রয় বন্ধকাদি রাখিতে পারিবেন না, করিলেও তা আইনসঙ্গত অগ্রাহ্য ও দণ্ডনীয় বলিয়া গ্রাহ্য গণ্য হইবে। So this term is very clear that land is available with me and the landowner can't even transfer the land in any manner. 7, লিজকৃত সম্পত্তির শ্রেণী পরিবর্তন করিতে লিজ দাতাগণের কোন প্রকার আপত্তি থাকিবে না। 8, প্রথম পক্ষ লিজকৃত ভূমির উপর পেট্রোল পাম্প ব্যবসার প্রয়োজনীয় অফিস রুম, স্টাফ কোয়ার্টার, সাবমার্সিবল পাম্প বসানো, টয়লেট ও পেট্রোল রিজার্ভার প্রভৃতি যাবতীয় নির্মাণ কার্য তাহার নিজ ব্যয়ে সম্পন্ন করিবেন এবং এতদর্থে সর্বপ্রকারে জমির শ্রেণী রূপান্তরকরণের জন্য দ্বিতীয় পক্ষের যে লিখিত সম্পত্তি সহ অপরাপর কাগজপত্রের সাক্ষ্যাদি প্রয়োজন দ্বিতীয় পক্ষ তাহা দিতে বাধ্য থাকবেন। এন্ড প্যারা 9 is very much clear. দ্বিতীয় পক্ষ যদি ভবিষ্যতে কোনো কারণবশত লিজকৃত সম্পত্তি বিক্রয় করিতে রাজি থাকে, ইভেন হি ওয়ান্টস টু সেল দ্য প্রপার্টি, তবে সেক্ষেত্রে প্রথম পক্ষকে বিক্রয় করার জন্য বাধ্য রইবে, তাহা মার্কেট মূল্য সম্মত হইবে। So land is available with me. If the landowner wants to sell the property, he ought to sell to me. So the terms is very much clear. The term 6, terms 9 is very much clear. Judgment গুলো ডিস্টিংগুইশ করবো, চিন্তা না। লিজকৃত সম্পত্তিতে ব্যবসার প্যারা 10, লিজকৃত সম্পত্তিতে ব্যবসার প্রয়োজনীয় যে কোনো প্রকার সরকারি কার্যে এবং কাগজ তৈরির ক্ষেত্রে লিজ দাতাগণ স্বাক্ষর দিয়া সহযোগিতা করিতে বাধ্য থাকিবেন। So every terms is there. প্যারা 11, লিজ দাতাগণের মধ্যে কাহারও মৃত্যুন্তে মেয়াদ থাকাকালীন মাসিক ভাড়ার টাকা সেই লিজ দাতার বা লিজ দাতাগণের ব্যাংক অ্যাকাউন্টে যে নমিনি থাকবে সেই ওয়ারিশ বুঝিয়া লইবেন। লিজের মেয়াদ শেষ হইলে নতুন করিয়া লিজ নবীকরণ করিতে এবং তখনকার বাজার দর অনুযায়ী মাসিক ভাড়া ও বাৎসরিক ভাড়া ধার্য হইবে। দিস ইজ পারপাস অফ রিনিউয়াল। প্যারা 16 ইজ পারপাস অফ রিনিউয়াল। তো এভরিথিং ইজ দেয়ার। লিজকৃত সম্পত্তি আমরা লিজ দাতাগণ লিজ দেওয়ার পূর্ব মুহূর্ত পর্যন্ত কোনো প্রকার হস্তান্তর করি নাই বা করা নাই। প্যারা 14, লিজ গ্রহীতা লিজের মাসিক ভাড়া লিজ দাতাগণের নিজ নিজ ব্যাংক অ্যাকাউন্টের মাধ্যমে প্রদান করিবেন। যদি লিজ দাতাগণ গ্রহীতার কোন পক্ষের কাহার লোকান্তর ঘটে তথাপি অত্র লিজভুক্ত চুক্তিময় ওয়ারিশগণ মধ্যে বলবৎ ফলবৎ থাকিবে, মেয়াদকাল উভয়ে সমভাবে সকলে মানতে বাধ্য থাকিবেন। 1/1/2024 হইতে 30/6/2054 পর্যন্ত নির্ধারিত 29 বছর 6 মাস মেয়াদ অতিক্রম হইবার পর 20 বছরের জন্য উভয় পক্ষের সম্মতিক্রমে উপরিক্ত নিয়ম অনুযায়ী লিজ এগ্রিমেন্ট পুনর্নবীকরণ হইবে। সো দ্যাট ইজ ফর দ্য পারপাস অফ রিনিউয়াল। যদি লিজকৃত সম্পত্তি লিজ পিরিয়ডের মধ্যে কোনো কারণবশত সরকারি অ্যাকুইজিশন ভুক্ত হয় সেক্ষেত্রে প্রথম পক্ষ লিজ গ্রহীত ওয়েল কোম্পানি যে পেট্রোল পাম্প থাকিবে সে কারণবশত কম্পেনসেশন গ্রহণ করিবেন এবং দ্বিতীয় পক্ষ কেবলমাত্র তার জমি উদ্যোগের জন্য, দ্যাট ইজ they have no application in this case. So terms is very clear, specifically para 6 and 9. If they want to sell the land, they ought to sell to me. I have the exclusive availability of the land. That brochure says about two things. You have to be registered deed and you have to be land available to you. Yes, I expressly say so. Land is available to me, and in every terms, land is available to me. Land is available for in terms of lease date 29 years 6 months, and if they want, the landowner want to sell the land, they ought to sell to me. And not only that, for renewal purpose another 20 years, my lord, I can possess that land. Second thing is that, my lord, my learned friend time and again argued on the on the point of possession, but there is no such mentioning of possession. My lord is well aware the fact OMC naturally, my lord, they argued on that point. They want to construe their legal point or any factual point on the basis of the brochure. They can't deviate from the word which mentioned in the brochure. In the brochure, there is a specific mentioning about two things. One is registered deed, another is availability of land, and both is with me. And the judgment that my learned friend cited have no application in my case, and not only that, specifically.
Okay.
Extremely good.
Were placed in the reply. Certain new clauses were placed on in reply.
Please let me dictate now. I have heard at length.
No, the new
But
clause.
I again will argue.
My learned friend has placed
Hey.
new clauses. At the first instance, he had not placed it. In
It is
each and
stable
every
for
only a short thing, madam. In each of the clauses which my learned friend has relied of the lease deed are applicable during the tenure of the lease deed. Everywhere it says
Then on
during
Friday.
Hello?
Then come on Friday. Or else conclude your argument. There has to be a, you have to stop somewhere.
Yes.
Madam, I'm not. Madam,
They're not
I am not.
mentioned in the-
I am
in
not
their
supposed to
email.
give a reply in reply. It's not permissible. Why? Since my learned
Let's
friend has
see
placed new
whether any
new
is
clauses.
created or not. Arjun, affidavit service filed on behalf of the
Yes,
petitioner
my lord,
taken
deliver
away.
service, my lord. Yes, my lord.
The petitioner's case in nutshell is that he or she applied for
Madam, I'm sorry, madam, I'm interviewing. Losses is deciding the repetition.
applied for dealership. This is LPG or petrol pump? LPG.
No, retail outlet dealership.
Retail outlet dealership. In respect of the advertisement published in Anandu Bajar Putrika by respondent number 3 on 18 July 2023. The petitioner was the loan applicant in respect of group falling under group 1 of the advertisement. The last date for such application, for submission of such application was 17th October 2023. As a petitioner applied for number 27 September 2023. 27 September 2020. The petitioner was informed by the Indian Oil Corporation Limited, within bracket, hereinafter referred to as IOCL, its later dated 20th October 2023, that she has been formally, provisionally selected, and she was called upon to submit relevant documents No, it will be declared. Baki, already selected. On 9th May 2024, upon perusal of the land documents submitted by the petitioner, she was found to be ineligible since the offered land in the application by way of lease deed was not in her possession. The petitioner thereafter on 13th May 2024 made a representation before the respondent IOCL to reconsider her application. By letter dated 13th May 2024, such prayer was turned down. Hence this writ petition. Mr. So and so, learned advocate for the petitioner, submits that as per clause 6 of clause 4 6A, the offered land should be available with the applicant as on the date of application, and the period of minimum lease should be 19 years and 11 months from the date or after the date of advertisement, but not later than the date of application. The brochure does not spell out of any possession of the land on the date of application. Therefore, rejection on the sole ground of not having possession is not within the rules of the brochure of respondent IOC. Be that as it may, the lease deed was executed on 27th of September 2023, which is much prior to the last date of application. Referring to the decision of this court passed in Sri Baneshwar Pal versus Srimati Nirmala Jyoti, reported in AIR 1979 Calcutta 396, he submits that the actual interest of the lessee commences on the execution of the lease, and therefore, even if the period of the lease is to start from a posterior date or from an anterior date, the interest of the lessee is created, which clearly suffice that the land offered by the lessee was available with her. The period mentioned in the lease deed is only for the sake of computation of the rent of the rent, and it has got no relation whatsoever with the commencement of the lease. Since it is palpable from the lease document that it has been registered on 27 September 2023, the right of the petitioner as a lessee on the offered land was created on such date. As per section 105 of the Transfer of Property Act, the lease of a immovable property is a transfer of a right to enjoy such property for a certain time on payment of consideration of a price paid or promised. Section 105 does not provide that that lease is to commence from the date of the period of payment of rent. Therefore, in light of his aforesaid submission, he prays that the finding of respondent IOCL that the petitioner is ineligible, vide letter dated 9th May 2024, is perversive and should be set aside. He further prays that the matter be remanded to the respondent IOCL for fresh consideration of the application of the petition. On the contrary, Mr. Amit Kumar Nag, learned advocate for respondent IOCL, submits that the clause of the lease deed clearly says that it would be effective from 1/1/2024 till 30th June 2054. The transfer of enjoyment of the property and delivery of possession of the property is sine qua non for creation of a lease. until and unless the possession is delivered to the lessee, no lease comes into subsistence. In support of his contention, he relies on the decision. What is this reference? Anwar Ali ILR. no? Anwar Ali Bapari versus Jamini Lal Ray Chaudhary, reported in ILR 1939. What is page 254? 25. And 1989, volume 1, এটা পার্টির নামটা দিয়ে দেবেন, SCC 19.
মানে in for this 1989 1 SCC 19 I wanted to rely on para 19 of that. 19, that twin principle, one of the twin principle tests by which a lease is distinguishable from the relation created under a license is the element of the right to exclusive possession involving the transfer
that
of
is
an
that.
interest in the property,
Okay.
the other being the rate stipulated. So rent is also two things, exclusive possession and rent, both are to be there.
কি বললাম? হ্যাঁ, ওখানে and ওইখানে একটা বলো ট্রান্সফার অফ পজেশন। হ্যাঁ, এখানে শুধু ওইখানে দুটো টুইন এ হচ্ছে, the other being the rent stipulated for grant. Since the lease itself says that it would be effective from 1st January 2024, there was no lease subsisting on the date of application. And therefore, the respondent IOCL has rightly rejected the application of the petitioner on the ground that he was not in possession of the offered land. To buttress his contention, he relies on the decision of Honorable Supreme Court passed in 2021 SCC Online SC 852 and 2022 SCC Online Calcutta 303. He also indicates that the petitioner in her representation has categorically stated that she acquired to enjoy the leasehold land. She acquired to enjoy the leasehold land from 1/1/2024. Therefore, it is undisputed that the petitioner was not in possession of the land. In light of his aforesaid submissions, he prays for dismissal of the writ petition.
But, the another judgment of the our division bench, my lord, the
Both
Sumar Shah.
I have noted.
Well, for showing this judgment, what I intend to show that it's not only the possession, there was no registered lease deed as on the date of possession, as on the date of application. So far as the offered land is concerned. Because clause 4 says availability as well as registered lease.
No, the division bench says as well as Honorable Supreme Court says that there was no subsisting lease.
Right. There was no subsisting lease.
Ah.
My requirement was that there was.
Registration is there, but whether it subsists or not,
Yes, yes, registration is there.
That
There was
is-
no lease, subsisting lease.
that is what I am recording.
No, your losses are recorded side minus the perhaps position.
No, that is separate. এগুলো তাহলে আমি বললাম না এগুলো decision to buttress is contains relies on this. The position which you have refuted with regard to his representation that has been noted.
In the representation, the effect, the tenure, the currency.
Having heard the learned advocates for respective parties, the only issue which has fallen for consideration is whether the petitioner was having a subsisting lease on the date of application and whether the offered land was available with her on the date of application. It is not in dispute that on the date of application, that is 27 September 2023, the petitioner entered into a lease deed in respect of the offered land. The period of the lease commences from 1/1/2024 to be effective till 30th June 2054. Section 105 of the Transfer of Property Act defines lease as follows. The 105 table. Upon bare reading of the aforesaid provision, it is found that for creation of a lease, twin conditions has to be fulfilled. One, that the lease of immovable property is a transfer of right to enjoy such property, and for payment of the rent for a certain period. Clause 4, 6. Clause 4. Clause 4, 6A of the brochure clearly indicates that the offered land should be available with the applicant as on date of application. Upon going through the lease deed dated 27 September 2023, nothing has been spelled out clearly that the offered land was made available to the petitioner on the date of execution of the lease deed. The twin principal test, twin principal test by which a lease comes into existence. Number one, the right to exclusive possession involving the transfer of an interest in the property and the rent stipulated by way of consideration for the grant. In the present case in hand, we are dealing with as to whether right to exclusive possession was delivered to the petitioner in creation of the lease deed. It is a fact that in the representation dated 13th May 2024, the petitioner, in clear terms, has stated that she acquired to enjoy the leasehold land to have effect from 1st January 2024. She has further stated that the enjoyment of the land was deferred till 1st January 2024 to avoid payment of rent amounting to rupees 55,833 per month. Such statement made in the representation by the petitioner goes without saying that there was no transfer of possession plus the right to enjoyment of the property was delivered to the petitioner on the date of execution of the lease deed. Though Mr. Quanso, learned advocate for the petitioner, tried to, referring to Sri Baneshwar Pal Sutra, tried to impress upon the court that the commencement of the lease and creation of actual interest commences on execution of the lease deed. Yet, it is it manifests from the above documents that there was no transfer of possession of the land. Which leads to the aspect that the availability of the land as required under the brochure was not also made over to the petitioner on the date of application. I find substance in the submission of Mr. Nag relying on Uma Saha Supra and Annapurna Jaiswal Supra in this regard. Since the land was not available on the date of the lease deed, there was no subsisting lease deed on the date of application. In light of the above discussion, the writ petition falls short of merit. Accordingly, WPA 14366 of 2024 stands dismissed.
I'm grateful.
Thank you very much. Yes, we have a book, Mr. You take this back. You can take this back. Thank you. I know to conclude that. Today's second.
My anxiety is, if after vacation, determination is changed, my lord, I will be deep sea.
Deep sea.
Anytime, my lord.
I don't want you to be in deep sea. We'll come back after vacation.
But then, my lord, kindly record the part of my body.
Then on Friday, you take your chance. On Friday.
It is not recording.
On Friday.
Right?
Friday I have some.
Well, let him conclude now. Huh? You have concluded.
I have some.
Now he says that he has an apprehension that there might be a change in
keep
the
the matter for hardened part and take it up after vacation.
on Friday.
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 Number one, my lord, otherwise,
It করে দাও. Item number 1. How long you will take?
half an hour until.
Half an hour. Okay. What is the item number?
I
Today?
18 months.
18.
18.
From 9 you have gone down. Yesterday it was 9.
Yeah.
It was, I cannot book it. Yes, sir.
Yesterday. Anyway, I take it up to on Friday.
Friday, my lord.
Friday তে কিছু আছে? Friday তে এটাকে conclude করে দেবেন. Ask the learned advocate for the state to remain present. Is it required for going through the pen drive, which we have indicated on the course of hearing?
If pen drive was supplied, do not know it was supplied to your lordship.
No, this has not been supplied and not been argued because
Not
there was an
Not
inquiry report which says that there was
proverbial memory. Really, my lord?
that you have made me like
Yes.
on Friday.
Obliged to your lordship.
Thank you. কোথায় গেল? চলো। কি করে ভেবে ধরো ওটা প্রথমের দিকে এলেই ভালো হয়। ওর উপরে কি আছে? তুলে দাও, ওরা বলছে তুলে দাও। সমস্যা নেই, দুটো থেকে গেল তাই রে। আটটা মোশন হলে কি হিয়ারিং এ যাবেন বলার জন্য? কি করবো, মোশনটা তো আগে নিতে হবে, মোশনটা তো আগে নিতে হবে না। ঠিক আছে, ফ্রাইডেতে দেখবো, যদি হয় ভালো, নাহলে দেখে শুনে পড়া কি করবো।
For the respondent.
Then I need to know what is the fate of the order. Order was passed to the BLRO for some compliance. He says that this has not been done and there is a mistake in the title suit number. It will be done.
That is not the application.
But if the order has been complied, taking into consideration title suit 12 of 1980,
Then there is no necessity for the correction. Then kindly give me some time. I'll consult the records and come back with the instruction.
because 1995, the order has not been complied. That is also
Just for
will you just find out and come back.
I'll find out.
Mr. Oyon Banerjee, an advocate for the state respondents, seeks accommodation to take appropriate instruction in respect of the order dated 8 December 1995 passed in CO 16738 within bracket W of 1995, 1 week after the vacation. Why so long, sir? If they have not could not have complied because there is a mistake in the title suit number, after 30 years you come and say why this was not indicated? The applicant is alive. Applicant or substitution is required. You take the instruction.
So, small correction under 152. But the delay he has to explain and whether it has been carried out or not. I'll take instruction.
You have given a copy of that application?
The copy has been served, only when the order is not illegible. I have requested my lawyer to give me a legible copy.
Next. Sixth May, 20th May. Have you been filed? Does appear, sir? Who is for the respondents? Shakti Talukdar.
Your Lordship, my senior Mr. Satyajit Talukdar is appearing for the KMDA in this matter.
State you have not served? Who appeared for this? You have not served the application upon the state respondent. Mr. P.B. Mahato appeared for the state respondents. So their applicants file an application. Hello. Mr. So and so learned advocate for the petitioner submits that he has served copy of the application, the restoration application upon the respondent number 5 KMDA. It is found that the application for restoration being CAN 2 of 2024 has not been served upon the state respondent. Learned advocate for the petitioner is directed to serve copy of the CAN application upon the learned advocate for state respondents within the returnable date. Let the matter appear 1 week after the vacation under the same heading. আচ্ছা, he files copy of the notice উপরে submission করলো যে KMDA এ করেছে, সেই copy of the notice which is taken on record. Serve a copy of this application upon the state respondent. Next. Next document. Service. Affidavit of service. And is a valid. CAN 4 of 2024. This is an application for condonation of delay in filing of the restoration application. Mr. So and so learned advocate for the petitioner submits that the instant writ petition was dismissed for default on 22nd January 2024. Submits that due to Non-appearance of the learned advocate on record. The writ petition was dismissed for default on 22nd January 2020. He seeks for due to and the clerk of learned advocate on record could not follow the daily list. Top. Due to such reason, there is delay of 61 days in preparing the application for restoration of the writ petition. He seeks for condolation of such delay. Despite service, none appears on behalf of the state respondents in a claim. Who appears? State respondents. None appears on behalf of the respondent. It is contended in the application that the clerk of the learned advocate on record, due to the wrong recording of the number of the writ petition, could not follow the matter. On 22nd January 2024, due to such reason, the learned advocate on record on behalf of the petitioner was unable to appear. Resulting in dismissal for default. The cause shown is sufficient to condone the delay. Accordingly, delay of 61 days in filing the restoration application stands condoned. The application being Can 4 of 2024 stands allowed. Can 3 of 2024, this is the application for the restoration of the writ petition. Same, the restored writ petition was dismissed for default on 22nd January 2024. Same, so the conditional delay to থাকবে না, same submissions. The application accordingly the order of dismissal dated 22nd January 2024 stands recalled. The writ petition being number 23103 of 2012 is restored to its original file and number. Affidavits are complete.
Yes. Yes, madam. No, my lord. I'm sorry. Affidavits have not been called for. No.
Let the writ petition be listed 1 week after the vacation. Ready. Still hearing.
My lord, kindly see, my lord, last order we have communicated to the lord advocate for the state.
You are for the state.
No. The kindly see, my lord, 113.5 order, like, my lord, directed them to produce two particulars for a sitting and to give particulars. 13.5 order. We have communicated that order and he has acknowledged the receipt of the letter. Today also my friend is not here.
He also communicated the order. We've spoken with him. He was supposed to sit with us yesterday. In fact, he had also fixed the order city. I'm told that perhaps he was held up because he had at our end communicated the order.
When this will come? Who is for this? Oh, Mr. Dey.
The Lordship recalls on the previous occasion we had an oral on my oral thing. I could produce nothing to show that, but now, my lord, we have gone in writing. Yesterday, we were told that he was outside court and he had some difficulty. We fixed up a time after my lord. Mr. Anirban Sarkar, his junior, said that he was out of court. He had some difficulty.
Mr. Dey has not come, Mr. Banerjee?
No.
His presence is required.
Now, every time notice has been given, this is nothing for to decide on merit. That will come afterwards. There is a possibility, Mr. Banerjee says that there is a possibility that the matter can be resolved out of court. Now, I ask the parties to sit down and find out what is the course can be adopted for resolution. But he says that respondent number 5 has also given notice. The petitioner has also given notice to Mr. Dey.
So we are annexing the order of your lordship.
Proposed resolution.
To annex the order of your lordship.
We fixed a proposed resolution meeting also. After my lord, we could get it at 4:45 p.m. on 20th of May.
And again on 21st also.
21st also, my lord, we fixed it on. Yes. Petitioner said that he was not available on 28th. Then on 21st, we gave a notice again to everyone. Fixed a venue also.
Buddhadev Ghoshal, learned advocate for the petitioner, submits that the previous order passed by this court on 13th May 2024 has been communicated to Mr. Chondi Charan Dey, learned advocate representing the state respondents. Mr. Arindam Banerjee, learned advocate for respondent number 5, CESC Limited. He files copy of the notice which is taken on record. Also informs the court that his client has issued a notice for meeting pursuant to the order passed by this court on 13th May 2024. Proposed to be held on 20th May and thereafter on 21st May. However, no response was received from the side of the state respondents.
Junior said that he was not available on the 21st. I must be candid to your lordship. On 20th, the petitioner had difficulty. On 21st, because there was election in Howrah and Delhi, so the petitioner's advocate council had difficulties. On 21st, we refixed it. They were ready to come. Mr. Dave Junior, Mr. Anirban Sarkar, my lord, has told us over telephone that his senior will not be available today because he is out of court. So, Lord, I must be candid to your lordship regarding what is.
Let the matter appear after 1 week of the vacation. Date ki diya sir? 22nd, 24th kar din. 24th June. State respondents are unrepresented. Learned advocates for the petitioner is directed to communicate as well as respond number 5. That will communicate the order to state respondent, advocate for state respondents. When the meeting will be held, that is up to the parties.
Yes.
Beginning on the 24th June. In the meantime, work out or let's hear out the matter, whatever.
It will retain its position.
এটা টপে দেখো, টপে আছে দেখুন তো, গ্রুপ 1 এ টপে আছে না? কটে করবেন না, এই নিন, হ্যাঁ 25th এ দেবো টপে, 25th টপ।
The communications will be kept on record.
Yes, yes, sir.
Lord, in this matter, I beg to appear on behalf of the petitioner if your lordship.
About the
And-
statement, two affidavits were directed to be affirmed, my lord, and it was given till today. I was directed to serve a copy upon them, lord. Since affirmed today, but I couldn't serve, now I'm serving.
আমি নেবো না নেবো না
Affidavit in opposition,
রিকুয়েস্ট করছি রিকুয়েস্ট করে দিই as your lordship.
affidavit in
I shall have to file my lord the
reply.
this is opposition.
Opposition, we had one additional affidavit. One additional affidavit for direct, I was supposed to not file the documents regarding not the payment made.
So affidavit in opposition on behalf of respondent number 126 to the supplementary affidavit of the writ petitioner is taken on record, copy served. Additional affidavit in opposition on behalf of respondent number 126 in compliance to the order of this court dated 4th July 2017 is also taken on record, copy served. Miss Usha Maiti, learned advocate for the petitioner, seeks accommodation to file the reply to the affidavits in opposition filed on behalf of respondent number 126 state respondent numbers 1. When
2 weeks after vacation.
let such reply, affidavit reply be filed within 2 weeks after the ensuing summer vacation, and the matter appear after 2 weeks under the same heading. 6.
Under the same heading, your lordship.
Yes.
Get put your lordship. অয়ন আমি তুমি তো কতদিন নিলে 17 সাল থেকে 4 বছর
Yes.
আমি ক বছর নিব
He's saying that there is considerable delay on my part.
after completion of 5 years my learned friend has served it. Order was of 2017. 7 years.
Supplementary, they have.
Your lordship order was passed in this year, but original order was passed in the year 2017.
Supplementary, they have filed in 2024. In 17, within 4 weeks, they were to file. They have filed in 2024. I'm using the.
But whatever it is, parent order is 2017, your lordship.
Additional affidavit is mine.
You get put your lordship.
In this case, my lord, I am for the petition.
What is this can?
Can my lord, for amendment of the prayer, but your lordship mold the prayer. In 226, the prayer may be mold. But my lord, I made an application for safeguard for amendment of the prayer.
Then you withdraw the application.
Yes, my lord,
If it is
only
not
allow,
required-
only allow the application, my lord.
Who is for the state?
The state, my lord, in several locations, my lord, not coming into court.
By the your lordship directed, I went and personally informed
আচ্ছা,
them.
এটা
Right.
ঠিক করতে হবে অর্ডারটা। আচ্ছা, না, এটা এটা ঠিক নেই তো, 22 হবে না, 23, এইটা ভুল হয়েছে, এই অর্ডারটা ঠিক আছে।
Yes.
Incorporated. Oh, why this Mr. Roy is not appearing? You have served the copy?
Yes.
Yeah.
Kindly see my lord amendment. Paragraph 6, if your lordship, my lord. Only last paragraph. Last paragraph of the order dated 3/6/2011 passed by the Assistant Secretary of the Government of West Bengal, Commerce and Industries Departments, Gamag Street, Calcutta 16, which is annexed P14 to the resolution.
Order dated June 20.
Dated, my lord, 3/6/2011, the Assistant Secretary order. Page, my lord, the starting page, my lord, 62, 63. In the order itself says, only last portion, I have carefully examined. Page 63, if your lordship. And earlier part, my lord, is in my favor, that the petitioner is eligible, and there is no doubt the petitioner is not eligible. But last part says, my lord, the one writ petition is pending of Rajgaon. That's why he is not inclined to dispose of the matter. And that part I have challenged that part also. I have carefully examined all relevant papers that filed to my lord. I have carefully examined, if your lordship got it. And that part I have challenged, my lord, if your lordship. But earlier part is in my favor.
Page 62.
62, my lord, up to, my lord, get priority. Second paragraph, up to second paragraph. 63. It is my favor. But one writ petition is pending, that's why he is not able to. And that writ petition is not hit my case, because, my lord, there is separate case.
63 of the writ petition.
Yes, my lord, writ petition.
Totally or not?
Non-application of my totally. Joining. Oh, Tonay Chakraborty. Okay.
What is the order passed in Rajgaon?
Rajgaon, my lord, that is a different matter, not in connection with my case.
Not at all.
And my lord, apart from that, I also obtained the certified copy of the order. The plot number is different, and one criminal case is pending against Rajgaon.
Why did it say that
Yes.
it is hid by Rajgaon? What is the finding in Rajgaon?
Fighting, my lord, that illegally, my lord, the authority put his case number. No connection. Not at all, my lord. And plot number is different, my lord. My plot number, kindly see, my lord, 2222, my lord, 5. Two to 5, page 25, if you lordship, my lord.
Rajgaon is pending.
I don't know, my lord, whether it is pending or not.
Not at all.
And not at all connected in my case.
Pritam Babu.
not at all connected in my case.
Wait.
And my lord, I supplementary affidavit also kindly see, my lord. Plot number is different. Page, my lord, 75 to 76, or original 73 to 74. Voluminous. Kindly see, my lord.
Pritam Babu, দেখুন WP number 9143W of 2010 এটা কি অবস্থায় স্টেজটা দেখুন তো WP
76
number 9143 within bracket W of 2010
and 76, my lord, Rajgaon plot number 76, kindly see, my lord, if your lordship. 2529 to such and such, but my plot kindly similar 76 of the supplementary affidavit. I collected the copy as per order of the Honorable Court from the Rajgaon. Page 76 of the supplementary affidavit, voluminous, second supplementary.
Who has filed this?
Written Bengali. Written Bengali, my lord, if your lordship, page 76.
This is supplementary affidavit dated
Supplementary affidavit dated, if your lordship.
5th December.
Yes, the kindly, my lord. Yes, my lord, December 2017.
Page number 76 is
76, if your lordship, page 76.
Written in Bengali.
And that is the writ petition of the Rajgaon. I have wrote a letter to the, as per order of the Honorable Court, I wrote a letter to Rajgaon Stone Company. And my lord, Rajgaon
not matching.
not matching.
What is the number? Page number is not matching.
76, if your lordship. 76, if your lordship.
76 is nothing. It is a showing seal and all.
Hey, Dada.
Should do this. Place control. অটোটা শো করছে মানে আপলোড করেনি
Dispose of.
and the order was passed by the state respondents on which date? Huh? When was the order passed?
Rajgaon, dispose of. Yes, my lord.
Where is the order of disposal?
But I have not, because my lord, I have not party in that case, because no land is not connected in my case.
That is what you were saying.
I tender apology once. I know this matter was called earlier also. I could not be.
Oh, sit down, sit down. Take your seat.
Take your seat.
You take your seat after take 1 minute, 2 minutes time. Take your seat.
I tender apology. One of the difficulty is it's a 2012 matter. I have also entered the in 2024 it's a matter. But I was only praying. I know a lot of time has been taken. I possibly had taken time. It's my lord, I take the responsibility. My lord kindly fixes this matter 1 week after vacation. I will personally be there, my lord. I'll be there. I'll do the matter. I'll complete.
Okay. You have received the application for amendment?
No, I have received supplementary.
An amendment? Photo petition.
I have received the writ petition supplementary affidavit.
What by way of the amendment application? They are praying for amendment of the prayer. Because they say that their representation or application was not considered and kept pending since it is hit by a order passed in another writ petition. It is their contention that the plots are not similar to the other writ petition and this writ petition.
Not at all
And I think you need to go through the application. Give a copy.
Yes.
My lord, give it.
Because, my lord, subject to correction, my lord, our format is subject to correction because 53A, capital A of the writ rule says, my lord, it's like a normal plain amendment application. You have to mark it as red lines. At least I do not find that amended writ petition has to be part of the, normally, my lord, we have learned from the lower court, my lord, court below, that is the more methodology. I do not find that the amended writ petition subject to correction, well, that is the format is also employed. Our writ rules also says that the amended copy has to be part of the amendment application because he has to ask for re-amendment, reaffirmation of the petition again, subject to correction.
You come back after taking instruction regarding this amendment.
Yes.
And if it is hit by the format, that can be clarified. He can take steps if the court decides for allowing the application.
The supplementary, if it is, I have not been served with this.
Mr. Mr. Tanoy Chakraborty, learned advocate for state respondent, submits that the application for amendment being Can 2 of 2023. Inadvertent typographical error has crept into order dated 23rd April 2024, mentioning the Can number as Can 2 of 2022 instead of Can 2 of 2023. The Can application in the aforesaid order be read as Can 2 of 2023 instead of Can 2 of 2022. The other portions of the order shall remain unaltered. Mr. Tanoy Chakraborty, learned advocate for the state respondent, submits that the copy of the application for amendment being Can 2 of 2023 has not been served upon him. Learned advocate for the petitioner, you have given a copy?
Yes, yes.
Hands over a copy of the Can application to Mr. Chakraborty, learned advocate for state respondent. Mr. Chakraborty, learned advocate for state respondent, next line, seeks accommodation to take proper instruction. Will filing any opposition to this?
Amendment application. If it is required, I will file it. My lord is keeping it, I will file it within that time. Because normally, my lord, after
okay, you take instruction and come back.
Yes,
if
it is required, I will.
Okay. Now I am not indicating anything in the order. You come back with the instruction.
Yeah.
Let the matter appear 1 week after the ensuing summer petition.
I'm grateful, man. I unconditional tender application. Okay. My mistake, because I have been appearing for the petition. I know how it when they suffer because of non-appearance of the respondent. I tender apology.
Okay.
My lordship, part kindly, I just part Your lordship has been hearing it has for several.
What is part in this? There is a interlocutory application.
My lord is necessary.
Lord.
We'll be very grateful, my lord.
No.
No. Part-hearted, my lord can kindly keep it part-hearted.
No. Next order. Where is Mr. Dey has not come today?
He's my lord, he's in another court, my lord. I also in court number 10, my lord.
I am the petitioner. My lords, this matter is pending for long time. And lordship, you have heard several times. Lordship, this matter relating to West Bengal minor mineral rules 2002. Manage this application. Yes. And the issue is that there was at the time there was a renewal clause of the lease, long-term mining lease. So, and as per the provisions of Rule 12.2, of rules 2002, there is a provision as well as the lease deed. There is also a provision. There was provision for renewal clause, and in pursuant to that, lordship, a renewal application was made. Why not kindly come to page 37? Page 37, lordship. Kindly come look at a glance. Page 37.
Where is the report?
Sorry, Lordship, I'm sorry. In renewal application, Lordship, page 85.
Where is the report, Mr. Bottom?
Yes, sir, today I'm fine.
Page 37.
No, sorry, that is the renewal clause in the lease deed. Page 37.
Clause?
Renewal clause, page 37, Lordship has got.
Clause number 5 or 6? Which one?
Lordship, I'm telling.
No, these are not
Page
renewal clause.
37, clause number, Lordship. Sorry. Page 37. Page 37. Lordship, I'm sorry. This is not that. I'm showing. Lordship, inner page 37.
Achha.
Lordship, inner page 37. That I have also confused. Inner page 37. And the lease deed is the lease deed. In the lease deed, there is a 37 page. There is a renewal clause. Lordship has got. The mining lease shall be renewable for one period not exceeding a period specified subsection rule 2 of rule 12 of the said rules at the options of the lessee. Well, then kindly come, Lordship, the renewal application which I have made, page 85. Renewal application, page 85 in my annexure P5.
This has been rejected.
Lordship has got page 85 is the renewal application written 5th January 2013. The renewal application, Lordship, was rejected by the impugn order dated 30 January 2013, page 93. Lordship, kindly come page 93. Lordship has got?
Yes.
Page 93. Lordship, the renewal application of mining lease has been filed on such and such, that is after the amended provisions of West Bengal Mining Rules 2002 by notification dated such as such. According to this amendment, Rule 5 to 16 of the said rules have become non-applicable in case of riverbed mining materials like sand, and hence the renewal application under Rule 12(1) is hereby rejected. However, the applicant such and such. Lordship, this order, this amendment of this provision, provision of 2002, that the provision was introduced in 2011. Subsequently, this notification has been struck down by this honorable court. Lordship, I am on the last occasion. I have showed you, Lordship, and one judgment. Now, kindly take this judgment. This is that judgment whereby the division bench struck down this provision. This provision was struck down, has become declared as ultra virus. Lordship, so my renewal applications kept open for consideration. Lordship, moreover, this issue has already been dealt with by the coordinate page. Lordship, I am showing one judgment. Lordship, kindly have look. Lordship has got the relevant portions. Page 43 onwards, there is the relevant provisions. Lordship, and one I have judgment has cited that the coordinate bench dealt with this issue, and Lordships kindly have this order, wherein His Lordship Chaudhary, Justice Chaudhary has dealt with, and Lordships, if you Lordships come in my the last page, in last page, in WP number 9932 of 2012, Alpana Haldar versus State of West Bengal decided on 8 May 2013. Lordship, that Alpana Haldar judgment I am showing, placing. In Joseph, a coordinate bench of held that the order of rejection of renewal mining lease cannot be stand as the said order was passed on the basis of amended provision of 2011 of the West Bengal Mining Rules 2012 that was declared ultra vires by this honorable court in Shopun Sarkar versus such. For these reasons stated above, the instant is allowed impin order data such as is set aside and quashed. Response 2 and 3 directed to grant renewal of mining lease in favor of the petition on the basis of the application dates and such and such. Lordship, this order was passed on Lordship 25th July 2013, and the another Lordship, the Alpana Halda judgment was 8th May 2013. There's the coordinate base by the Honorable Justice Sengupta, and this order was passed by Honorable Justice Chaudhary. The same issue was decided by the two coordinate bench, and relying on those two judgments, Your Lordship, before Your Lordship. And my lord, His Lordship was directed to consider the renewal application as per the provision of 2002. Judgment. ये थे भी just 3 to 2. Yes, Lord.
2011 has been struck down.
Struck down.
So we are left with Rule 12 of 2002. State to act in accordance with that rule. Consider it. Yes.
But first of all, they have cited some judgment which is not reported. They have to see.
Yes,
What
I'm
judgment
giving.
they have said, I do not know, man. Have
This
to
one
go through
is
those judgments.
structured, and there was.
Mr. Bandyopadhyay appeared in Alpuna Haldar.
Yes, ma'am. They have to go through the judgment, ma'am.
The state respondent minus learned friends may not be, but his senior is well aware about these judgments. Yes, all
And
those two
our
matters.
case we have made out in paragraph, page 5, paragraph C, my lord, in my report.
Huh?
This is our report, my lord, 26, page 5. So paragraph C, my lord, we have, my lord, made out our case. The petitioner made an application on 15th of January 2013 before the respondent authority 3 for renewal of his mining lease for a further period
When
of
was
5 years.
mining lease supposed to expire?
Yes.
When? When?
Lordship,
That has been
the expired on Lordship 27 July 2030. 2030. 27
When did
July.
you make your application?
The lease was expired.
As per Rule 12, prior to 6 months of expiry of the lease, the application has to be filed.
Lordship.
You have filed it.
Get filed.
You have filed it prior to 6 months.
The petitioner made an application. Yes, that reason is there. Most probably there is some reason, but the impugn order, there is no such reflection. Why not kindly have look? Page 93. Now that subsequent stage, they cannot issue this raise. Whatever it, not to kindly come to my impugn order. Yes. Page 93 made it. Only on this ground, the individual application has to be rejected. Nothing else there.
Yes. When did you file the application? On 13th January.
I made an application on
30th January 2013.
15 January 2030.
And the lease was supposed to expire on?
This was expired on 27 July.
Lease expired on?
Lease expired on 27 July. Sorry, 27 July 2030. And
July.
application was made 15 January. Before, if this application was within time. Before 9 months, not before the 6 months. But there is a window, 6 months and 9 months. In between, I had made an application.
It is within time.
Within time. And as such, there is no such reflection in the order.
Well, see. Since amended rules 2011 has got no existence after the order passed in Shapun Sarkar. So the application cannot be rejected on the amended rules.
But our case is that they have submitted the application on 15th of January 2013, and it appears the petitioner submitted his application on 15th of after amendment, my lord. That is after the amendment notification dated 11th of 11/12/2011.
After the amended provisions.
After the amendment rules, they have submitted application. And as for rule 16B of 2002 rules, my lord, his application has been rejected.
It's the renewal. Then 12.1 has got no existence. 12.1 of 2011 has got no existence.
Yes, my lord.
Yeah. Now give it to all the other cases, the matter has been remanded back to the authority for consideration under Rule 12 of 2002.
It's that you should be granted, but with the cases that I have cited, their order was of entry order was passed lordship. So as your lordship can pay, but this order since this rule is amended rule is not there, lordship has the authority has the right to renew the applications.
They renew it, they will reconsider in terms of the order passed in summons or
Okay, what happened? What is happening in such matter? If your lordships grant me pass and such order for consideration, strict authority. I'm not sure, but I'm sure that that application will be rejected. And that order will be challenged under which provisions? Whether West Bengal rules or 16 rules, that the applicable rules, when that
if the order impugned order is under challenge, which has not been followed by applying the existing rules, then that order goes.
That order for no,
Now
I'm
existing rules he will apply. What you have referred to the decisions, the following exercise was undertaken, that is set aside, go for a further consideration, remanded back for refresh consideration.
So, lordship, I just remanded back to district authority and in presence of inconvenience with the lordship, the respondent number 2 be also be directed to them.
Respondent number?
Because respondent number 2, the respondent to district authority, and lordship the one. Respondent 1, principal secretary. This has to be should be knowledge. Aware of this.
The district authority is the appropriate authority. We will consider matter. District authority has no role.
ADM, Additional District Magistrate. Who passed this order? Additional District Magistrate.
Additional District Magistrate, DLR is the appropriate authority.
Yeah. What is your submission?
But my submission is this: my 2002 rule is not applicable. This rule has gone, my lord. And now, thereafter 2016 rules come, my lord. Now, my lord, 2022 rules is in prison. Lord, that case, my lord, now, my lord, the only problem, there is no provision for renewal. The only provision is they have to, my lord, participate in the auction process, e-auction process, as per my existing rules.
Where is the rule of 16 and 22?
There I have, my lord, annexed, my lord, in my report. Annexed R2, my lord, page 10 is the, my lord, 2016 rules.
And 16 rule is there, Lordship.
But section 62 of Rule 16 saves the actions taken under 2002 rules.
On the earlier objection, and Lordship.
It saves the action taken under the previous Rule 2002.
Lordship, I'm saying.
It was due to have been validly done or taken.
Lordship, Rule 62 surplus 2. Yes, there the stepping clause is there. Lordship, every issue has been decided. So, Lordship, Lordship. Well, at this stage, is the impugn order has no existence, should not be existing. Because and the subsequent events, they cannot also supplemented in an impugn order.
That is correct.
That is my case.
I also 2022 rules I have also annexed one, page 15.
Are you ready, Mr. Bottomwell, or are you ready with the facts?
But I have to go through those judgment which they have to rely on. I have not gone.
The Bantavada is there.
Or you also can fix the date when I will submit on that date.
Lordship, my part is complete.
Mr. Mir Anwar, you will not be filing any exception to the report?
Lordship, I think there is no such requirement.
Mr. Mir Anwar, learned advocate for the petitioner, concludes his argument. Mr. Theobrotto Bhattacharya উপরে রিপোর্টটা ফাইল করেছে। হ্যাঁ। রিপোর্টটা দেখলাম একটু। না, এই তো রিপোর্ট। Officer, Mr. Mir Anwar Ali, learned advocate for the petitioner, informs the court that his client shall not file any exception to such report. He concludes his argument. Mr. Priyobrata Bhattacharya, learned advocate for the state respondent, seeks accommodation to make his submissions. If the petitioner you just go through the judgments. If the petitioners in the other writ petitions is favored with the order for reconsideration or fresh consideration, then if the present petitioner stands on the same footing, he should be favored with.
When you lost it,
Petitioner for a date.
That also maybe was that what the coordinate bench has
submit. If you are ready with the hearing, then it's all right. If you are not ready, go through the judgments and make your submissions. After the vacation, at a date will go judge. And vacation report report or send draft visit করে দেব ও দুটো ইটটা বেশি করে first July.
First July. Also, 1 week after vacation. 1 week after vacation.
Oh, the 1 week after vacation. You দেখছেন না notification. 1 week after the vacation. না শুক্রবার দিন ওই 8টা মোশন আছে ওই যতটুকু হবে হবে আজকে তো একটা মোশনই লেগে গেল এখন 8টা থেকে ভালো কিছু নেই
all these judgment be kept with the records.
এই জাজমেন্টস গুলোকে একটা ফাইল করে দেবে Photo please. Great.
For the state, my lord.
For the petitioner, my lord, can it be after petition, my lord? There are some instruction, my lord, he has filed.
Today I am filing report, my lord. Forward. We have, the copy has also been served.
Supplementary report. Consideration of the inclusion of the report. Oh. You have received the enclosure?
Yes.
Legible copy has been given, no? You have received legible copy of the report?
My lord, legibility, we received the report, my lord, but legibility is a very much legible, my lord. But it is an old document.
Enclosure. Enclosures have been handed over. You have submitted that the enclosures to the report were not given. Now it is given.
And in the first report, the enclosures are not there. That is why lordship director has to file a supplementary report.
Supplementary report in the form of affidavit filed on behalf of state. Respondent number 4 is taken on record. Copy served. This Tanishka Bandyopadhyay, learned advocate for the petitioner, seeks for fixing the matter after the entry in summary petition.
Well, we shall find out reply by
Exception. You have filed your exception to the earlier report.
no, earlier report, no, my lord, because there was no enclosure.
So you file a consolidated exception to all the reports. Petitioner is directed to file a consolidated exception to the report and supplementary report filed by the state respondent 1 week after the vacation. So within a week of exception to within 1 week. 1 week after the next.
Mr. Timir Bolan Shah is appearing for the petition and praying for not today. After vacation.
Actually, disturbing. One of the parties. What is CAN 12?
My lord, I'm unaware of it. It's not my senior's matter. That's why.
CAN 12 पे ये है नहीं ना? Application, copy of the application has been served. CAN 12 dispose of it. So disposed of. अच्छा. Department. And so learned advocate for the
My lord,
petition.
application has been served.
Petitioner seeks accommodation. Seeks submits for fixing the matter after the entry. Do shop.
From the state.
It appears to be of the petition. এটা কোনো CAD application ফাইল আছে? এটা কোনো CAD application ফাইল আছে for restoration of the writ petition? এই যে পুরোনো 2002 না না এটা 13326 of 2012 কোনো CAD ফাইল আছে? উইথই তো এসছে, আজকে তুই উইথ আসছে না? ঠিক আছে। None appears on behalf of the petition. Yeah. The matter appear after 2 weeks. Huh? For instance, that is dismissal. একটা লিস্টে আছে ওখানে লাস্ট অর্ডারটা দুটো ছিল, উইথ ছিল কিন্তু উইথটা ডিসমিস ফর ডিফল্ট হয়ে গেছিল। ওকে লিস্ট করা যাবে না এখন? করা যাবে? তাদের একটা 2002 এর একটা পিটিশন আছে যেটা ডিসমিস ফর ডিফল্ট হয়ে গেছে, ওরা কোনো স্টেপস নেবে, স্টেপস নেয় যে কারণে অ্যাপিয়ার করছে না। আপনি একটাতেই অর্ডার দেন। এই প্রীতম বাবু অর্ডারটা একটাতেই হবে, না যেটা অ্যাপিয়ার করছে ওটা দিয়ে অর্ডার। হ্যাঁ রেকর্ডটা আছে, রেকর্ড আছে। তাহলে ওটা ডেজ লিস্টে ট্রিট করে নিই, রিট পিটিশন। এটা লিস্ট হয়নি কিন্তু রেকর্ডটা আছে, ওটাকে লিস্ট করে দিচ্ছি, ট্রিটেড ইন ডেজ লিস্ট করে উইথ করেই আপনি করবেন। হ্যাঁ, রিট পিটিশন নাম্বার such and such is treated in the days list. Special year file. Good for cheap. Yes. Yes. ঠিক আছে তাহলে
reply. Only thing, the lordship of the last occasion yesterday, they have relied upon the decisions rendered by the Supreme Court, that in amortizing case. There they have alleged that in my writ petition I have suppressed some material facts which is required to express in the writ petition, so that this matter can adjudicate this matter. Otherwise, this is a divide of substance because of this. In reply to judgment, I need to place that judgment itself. But your lordship, they have relied paragraph
50 to 62.
Yes. They have relied on 53.
50 to 62 he has read.
Yes.
Do you have a copy of that judgment?
My lord, I have a book. I have the book along. If you hand up to 53, then 54.
50 থেকে 62 দেখিয়েছে আমি।
My respective submission is that for the suppressions which they referred in my petition, the facts of the instant case and the facts of the case which they referred, that has to be followed. But there a statement under section 161 of the CRPC that was not disclosed in the writ petition in all sheets. That is why that paragraph 51. Apart from the aforesaid paragraph 51, apart from the aforesaid, in the writ petition which was filed on 21st of January 6, there is no mentioning of the fact that the petitioner gave a statement under section 161 of the Code of Criminal Procedure in connection with the investigations arising out of the on 30th of December 2005. From the record of the case, it appears that the petitioner gave a 161 statement on 13th January 2006. In the writ petition, there is a complete suppression of the aforesaid fact. A statement under section 161 is certainly a material fact in a police investigation in connection with an FIR. The investigation is to find out the genuineness of those very documents on the basis of which the petition was. In that factual aspect, total suppression is of the fact that the petitioner gave a 161 statement. If that investigation is, in our judgment, suppression of very material. Now,
Yes.
I will also going to come to page, the paragraph. Yes, paragraph 54. And paragraph 54 refers on a judgment delivered on to Lord. For that judgment, one of the paragraph is quoted here. It is the duty of a party asking for an injunction to bring under the notice of the court all facts material to the determination of his right to that injunction. And it is no excuse for him to say that he was not aware of the importance of any fact which he has omitted to bring forward. Now, there is the investigation initiated, started, the prosecution started the case Thereafter, the writ petition filed under Article 32. In this case, when the investigation started, the petitioner hearing a statement has been given under Section 161 of the CRPC that was suppressed. In this report, now, then paragraph 54 also says the requirement of disclosure of the fact where someone is asking for an injunction. So, that paragraph 54. Here in my case, this has to be differentiated in that way. Here in my case, I am not asking for an injunction or any restraint order or any prohibitory order against the respondent authority. Simply, I have prayed the hearing was taken by the authority, but the acquiring body upon a notice. No result has been disclosed about that hearing. So I am asking therein, in my writ petition, the prayer is very simple, that representation which has to be considered. First of all, there is no suppression in that effect, because the questions of asking the injunction, which has been referred to in paragraph 54, that has not been, I have not asked any injunction or any prohibitory order against the respondent. Second, your lordship can come to date 55. Custody verse 2. There also the paragraph says principle laid down. A plaintiff applying ex parte comes under a contract with the court that he will state the whole case fully and fairly to the court. If he fails to do that, and the court finds when the other party applies to dissolve the injunction that any material fact has been suppressed or not properly brought forward, it is told that the court will not decide on the merits, and that as has broken the faith with the court, the injunction must go. Second issue is that this is not a case in a writ petition where I have asked anything ex parte. This only comes when the additional stage is concerned in any matter. Where a prayer also made in respect of even writ petition, that rule 27 of the rate rule leave gives on that. There is no such prayer has been made without serving the court. So, but this is not ex parte. This another aspect. Then 56 Petrol case, Republic of It. If paragraph starts with, if there is an important misstatement speaking for myself, I have never hesitated and never shall hesitate until it's altered to discharge the order at once, so as to impress upon all persons who are suitors in this court and the importance of dealing in good faith with the court when ex parte applications are made. This is also simple. It is not I have got already any order, interim order, suppressing the facts which has to be bring before the court. I haven't got any order. Neither the ex parte order, not any interim order. So here one of these overseeing case, it has been started in 2006. Yes. From that point of that 2006, an interim order obtained by the petitioner therein also, and there are suppression of all along the interim order continuing. Only after exchanging the affidavit, find out one of these things. These are facts, and those are the material facts to obtain an interim order that has been suppressed there. But here is nothing. Not here, not there. This is not a case in my petition. Simply, I have asked a relief that my representation which has been made
pursuant to a hearing based, pursuant to a date of notice, acquisition of land, you have asked me, then I only based this, that I have heard about, you have distributed the awarded sum to some other person. What is about myself? Let me know, or let me give a decision to my decision. Assuming it is a plot, a suit plot,
Your final written statement,
and there in the
suit,
that I have. But I have to take, but I think well, this is a
You have appeared.
law old suit. He has already
you
filed.
have appeared in the suit.
But he is appearing, but I am not. They were not. I have to.
He means who? Plaintiff will appear in this.
But they are the lower court. The advocate is appearing. So they are not.
So you are represented in the title suit.
Yes, well,
Yeah. That's all.
And my humble submission is that, my lord, in the petition, the lordship put this, my lord, petition. There is no prayer made, restraining or injuncting or asking any injunction or privacy.
Awesome. This by this ওটা হয়েছে যাওয়ার আগে যদি by the present writ petition, the writ petitioner has prayed for consideration of his representation dated 6th December 2022. The petitioner's case in nutshell is that he is the owner of the land situated at Mouja Barma, jail number 73, PS Bolarampur, comprised within Dag/plot number 580, 581 and 582. The petitioner was served with a notice under section 3G of the National Highways Act 1956. Vide notice dated 9th February 2022. Asking the petitioner to appear on 17th February 2022 at 11:30 am with all relevant papers before the office of District Magistrate Purulia. Pursuant to such notice, the petitioner appeared for hearing and submitted necessary documents. However, in spite of such hearing, the compensation was not disbursed in favor of the petitioner. Accordingly, on 6th December 2022, the petitioner made a representation before the competent authority for release of compensation in his favor. Since no steps were taken for release of compensation, the petitioner preferred the present writ petition. Mr. So, learned advocate for the petitioner, submits that the petitioner has made an innocuous prayer for consideration of his representation dated 6 December 2022. Since after hearing on 17 February 2022, the release of compensation has been kept pending by the competent authority. He seeks for appropriate direction for sending the representation to be considered by the representation of the petitioner for consideration by the competent authority. Mr. Sambuddha Chakraborty Dotto, learned advocate for state respondents, submits that it has been categorically stated in the report of the state that the petitioner has no interest so far as plot number 580 and 581 is concerned. Though the petitioner is recorded as a riot in respect of plot number 582. However, the right title and interest of the petitioner in respect of the said plot of land has been challenged in a civil suit, being title suit number 222 of 288 of 2015, in which an order of status quo has been filed by the civil court. Thus, until and unless the right of the petitioner is decided by the civil court in respect of plot number 528, the representation of the petitioner cannot be considered. The petitioner has deliberately suppressed the pendency of the title suit filed by Sri Jagannath Mahaprabhu, represented by its Sevaits against the petitioner and others. It is a settled proposition of law that suppression of material facts None. Would lead to dismissal of the writ petition at the threshold. The litigants must observe total clarity and candor in their pleadings. Candor in the pleadings in seeking equitable remedy. To buttress his contention, he relied on the decision of Honorable Supreme Court passed in Amar Singh versus Union of India. They reported in 2011, Volume 7, SCC 669. In light of his aforesaid submissions, it referred for dismissal of the writ petition. Ms. Monica Roy, learned advocate for respondent NHAI, also submits that there has been suppression of material facts by the petitioner for getting favorable order from the court. Hence, the writ petition is ওইটা একটু উপরে এটা হ্যাঁ আচ্ছা উপরে ওটা করুন যে the right of the petitioner as stated in the report and the existence of the title suit has not been denied and dealt with. And as such, the respondent's case is also acceptable applying doctrine of non-traverse. আচ্ছা চলে এসো মিস মনিকা রয় 6 for dismissal of the writ petition. ওনাটা non-traverse এর সাবমিশনটা দিয়ে দেন। Having heard the learned advocate, in reply, Mr. So-and-so learned advocate for the petitioner submits that the facts of the case, facts of the cited decision is distinguishable, inasmuch as there was suppression by the petitioner before the court that is that the petitioner gave a statement under section 161 of the Code of Criminal Procedure in connection with investigation arising out of FIR lodged on 30th December 2005. Further, the decisions relied upon by the Honorable Supreme Court relates to passing of ex parte orders and injunctions, which is different from the prayer made by the petitioner in the present writ petition. Accordingly, the propositions of the aforesaid decision in Amar Singh Supra does not apply to the facts of the case. Having heard the learned advocates for respective parties, the only issue which has fallen for consideration is whether the representation of the petitioner should be directed to be decided by the competent authority in the facts and circumstances of the case. It has been categorically stated in the report that amongst plots number 580, 581 and 582, the petitioner is a recorded riot in respect of plot number 582 only. Okay, here. Such statement made in the report has not been denied in the exception filed by the petitioner. Therefore, it goes without saying that the petitioner is a recorded riot in respect of plot number 582 only. On perusal of report. The report of the state at page number, information slip page number, report
22.
The page number 22 R5, annexure R5 to the report reveals that title suit being number 288 of 2015 is pending before the civil judge senior division Purulia, in which a status quo order has been passed. The plaintiff of the aforesaid title suit annexed to the report at page 20. এটা না annexure 6 হবে ভুল করে মার্ক করেছে আর 20 আর ওটা পেজ নাম্বার 22 করলি না annexure দিতে হবে 20 shows that the suit civil suit has been filed by the plaintiff for declaration that the suit plot number 582 is a Devatkar property of the plaintiff number 1, who has exclusive right title interest over the said land. Therefore, it manifests that the right of the petitioner is challenged in the said suit. The entitlement of the petitioner, so far as compensation is concerned, relates to is based on his right over the plot in question. The disclosure of such fact is a material one. Throughout the writ petition, there is no such pleading disclosing of existence and pendency of a title suit, being number 288 of 2015. Such being the position, I find substance in submission of Mr. Dotto, relying on the decision of Honorable Supreme Court in Amar Singh Supra, that such suppression debars the petitioner from getting any equitable relief. In light of the aforesaid discussion, the writ petition stands dismissed. এটার তো কপি লাগবে না, লিখে নাও, সাইটেশনটা লিখে নিই তাহলে হবে। ঠিক। কাশি structure, accommodation, possession issue, exception আছে কি ওর খালি possession issue. Yes.
Example the petition, your lordship there. What was the last instruction?
What is your report? What is his name? Notice is at page number. Huh. Yes, please. What is the case of the petitioner that he is the owner? You are the owner?
No one. I am not the owner.
You are not the owner.
But I am not the owner. I was this position wherein
You are not the owner. What you do there? You are running a shop.
mine.
Ah. আছে তো আবার কি দিচ্ছে petition regarding public requirement. Yes, that is all. Yes, Mr. Please solve.
But your lordship will come after their report in page 3 of their report. Which
report?
Page 3 of their report. Report filed by
yes
2 and 7. Your lordship will find page 3 a comprehensive report in connection with WPA number so and so. Now your lordship kindly come to the from the last but one paragraph. It has been started. So the instant read payment, your lordship got it. So the instant read involved plot are not recorded in favor of the petitioner. I have never said that the plot is my plot. Elsewhere. Besides, during field inquiry, this is which happening me when the field inquiry held on, because this report only comes before after filing this read petition, and after serving and your lordship has directed to file a report, then they are saying today, I have also annexed early in my exception 2 documents. One is a photograph, another is a panchayat certificate bill in my exception. Exception page 4 R1. This is a Bela Gram Panchayat. Even for the structure, even not for the structure. Security fair rights to fair competition at sale.
P181.
Lot number 318 is a listed lot
His name is not a. He is not the patta holder. He is saying that he is running a tea shop within plot number. Ashok.
And 2 documents are
by the present read petition, the read petitioner has prayed for consideration of his representation dated 6th December. This is also 6th December. 6th December. The factor almost same. So the plot number to nearly is factorable. Petitioner's case in nutshell is that he is running a tea shop, tea shop within plot number that he is a permanent resident and running a shop within DAG number 3042, 3024, 3077, 3071, 3181 within Mouja Multi, jail number 78, PS Balarampur, where by constructing Pakka residential house / building and shop তারপর সেম হবে notice. When was the notice issued? আচ্ছা নোটিশের ডেটটা 23rd November হবে 2030 for appearance on 17th December 2019 ওই appearance এর ডেট ডাইরেক্টলি তাই Mr. Benazir Ahmed, learned advocate, আচ্ছা ওনার নামটা দিন Mr. Shankarnath Mukherjee, learned advocate for the petitioner submits that একই সাবমিশন তাই In reply to the contention raised on behalf of the petitioner, Mr. Benazir Ahmed, learned advocate for the state respondent, submits that the petitioner has no right, title, interest over the land in question. On field inquiry, no structures were found. Accordingly, there is no scope for consideration of representation of the petitioner for release of compensation in his favor. Ms. Monica Roy, learned advocate for respondent NHAI, also submits in the similar fashion. From the writ petition, it is found that the writ petitioner has not claimed any right in respect of the plot in question. Right, title, interest in respect of plot in question. The report of the state also reveals that there is no interest of the petitioner with regard to the aforesaid land. Save and accept, producing what is this?
Malathi, one is in my exception.
Yes.
This is the
Bela Gram Panchayat.
Yes.
Save and accept, producing a
and Malathi, one
receipt. This is a tax receipt. Tax receipt. There are no other, yes. But there are no other documents in support of possession of the petitioner or of any interest. In light of the above, the writ petition stands dismissed.
Equal share with
Report in the form of affidavit filed on behalf of the, give a copy to the petitioner. Filed on behalf of the state respondent is taken on record. Copy served. You have been served, Mr. Mukherjee. Mr. Shankarnath Mukherjee, learned advocate for the petitioner, seeks to file exception to the report filed by the state respondents. Let such report in the form of affidavit be filed by the report holder. Exception to the report be filed by the petitioner within 2 weeks of reopening after the ensuing summer vacation So let the matter appear after 2 weeks after the entering summer vacation under the same heading. So, we have a where is the report? Month. Who is for the state? সৌমিত্র বন্দ্যোপাধ্যায়। Mr. Shantanu Mitra, yes. The state is unrepresented. State respondent is unrepresented. For ends of justice, the matter stands adjourned. 2 weeks for a
Let this matter then appear after. It will appear after petition. Because Friday is very last day.
2 weeks after the vacation. You have filed your affidavit? No, it's ready then. Ready. Ah, 2 weeks.
My lord, the exception has not been filed to the report filed on behalf of the state. My lord, if your lordship sees, my lord, the last 4 orders, my lord, exception, my lord, they took time to file exception. Next time they took time to file exception. Third time no one appeared. Lordship, my lord, adjourned the matter in the interest of justice. On the last occasion, my lord, someone sought time. So, my lord, this is the situation.
Yes, file the report. The exception.
Murder. Murder.
Well, let it be again up day after tomorrow. BFC is not with me. Only day after tomorrow. I will. Exception is ready. I will file the exception.
My lord, then not today, my lord, perhaps, my lord, after the vacation. My lord, he only, my lord, sought
No,
time.
no,
in
no,
the
no.
other matter.
This is not the way. I'm not taking the time. I'm only saying that BFC is not with me. Let it be taken up day after tomorrow.
My lord, I am not objecting to his prayer. I am saying, my lord, kindly keeps it after vacation in that.
As you lordship.
Yes, yes. Because of the, my lord, last day, my lord, less chance of 3:30. My lord, to be, my lord, very candid and, my lord.
Shankar Nath Mukherjee, learned advocate, states that the exception is ready. However, the same is not with him at the present moment. He seeks accommodation. In the matter appeared from 2 weeks for a acts for the family.
I am grateful.
I am for the state respondent.
So, my lord, in this matter, my lord, Shubhavat Bhattacharya is appearing for the petitioner. My lord, yesterday he prayed before your lordship to pick up the matter after that. My lord.
The last week we could have told that it will be taken up on 15th May.
Yes, yes.
He has
Last
sought
day
for
also.
adjournment on 15th
Adjournment
May.
prayed for.
The pleadings are complete.
My lord, only one time I have prayed adjournment because on that day he has not come. My lord, kindly take it up after vacation.
Short dates are being given for hearing so that hearing can commence because it takes time. And then if you are not participating or you are not conducting your hearing, it goes to the other. Then on that day, what will happen? How many dates? See, 15th May, 25th April. 25th April, these replies were filed. They could have date would. Huh?
Order's petition is not willing to continue.
No, no, man. What are you telling me?
You're not interested.
Every day.
My lord, kindly next week, my lord, no, not possible Friday, my lord.
15
Can I take it up after
Friday.
vacation, after reopening, my lord, the matter will be.
Date बोलो तो 25th, 25th, 25th June. Huh? The passing order. Miss Srilekha Bhattacharya, learned advocate for the petitioner, seeks accommodation. Let the matter appear on. Pritam Babu, 25th बोला 25th June. Fixed under the same heading.
Yes, my
No, it is under the specially assigned. This will appear on 25th. You have to bear what to do.
As a last chance, madam.
ওই অর্ডারটা করে দেবে না শ্রীমানি বাবু
I am for the petitioner. Last occasion, my lord, it took time for filing my affidavit in opposition.
What is this report?
My lord, PWD has taken land, my lord, without paying compensation.
Who? PWD?
PWD. Without paying compensation or any proceeding.
Report. The road has started. It is operating.
Road is completed, my lord, over my land. Without application or paying compensation. Give me 1 week time and I'll reply.
There has to be two reports. One by respondent number 3 and the other by respondent number 4. Who has filed this report? State respondent director filed separate reports by respondent number 3 and respondent number 4. Separate reports. This is respondent number 2 and 3. So 4 has not filed any report. Who is respondent number 4? The respondent number 4 is
Well, land acquisition authority main authority.
Assistant engineer roads. You are representing both of them. No, there was direction to file by both of them separately. A report in the form of affidavit filed on behalf of respondent number 2 and 3 is taken on record copy, sir. By order dated 25th April 2024, both respondent number 3 and 4 were directed to file separate reports. Though respondent number 3 has filed its report, but respondent number 4 has not filed its report in compliance to the order dated 25th April 2020. Mr. Priyobodha Bhattacharya, learned advocate, seeks accommodation to file such report in terms of order dated 25th April 2024 by respondent number 4 within 2 weeks after the ensuing summer vacation. Advance copy of such report be handed over to learned advocate for the petitioner. Exception to such report be filed within a period of 1 week thereof. Let the matter appear 3 weeks after the entry. এগুলো ওই যে রিট পিটিশনস গুলো এখন করলাম ওটা যদি আপনি ফ্রাইডেতে দেন ঠিক আছে, যেটা ওই আইওসি এর যেটা আছে ওটা আমাকে দিয়ে দেবেন, ওটা আমি কারেকশন করব। হ্যাঁ আচ্ছা, দুটো যদি হয়ে যায় ভালো, কিন্তু ওটাকে আগে করবো। হ্যাঁ কোনটা কোনটা বুঝতে পারছি আছি তো এখন জাজমেন্ট আছে 5:30 থেকে 6টা ফার্স্ট। চলিয়ে